fixed, Lordship. Similar matter.
Mr. Shah is coming.
Yes, he is also not coming.
Today it was fixed over
Yes, Lordship. Item 22.
on the alternative remedy.
Yes, alternative.
Okay, yes.
I'm mentioning six.
It was fixed today, right?
Lordship.
It was fixed today.
Yes, Lordship. Total 10.
And
matters.
let all the matters be listed together.
Lordship.
18th of May is the agreed date for all of you.
Lord.
In Mr. Shah's matter, who
Yeah, my lord, I am appearing in this matter. Item 22, my lord.
we'll have it on 18th of
My
May.
lord, oblige.
And don't write. There's a request for adjournment on behalf of the petitioner. Full stop. Since a preliminary objection has been raised in these petitions regarding the maintainability, comma, let all these petitions be listed together on 18 May, 18/5/2023.
There is an interim order.
Interim order passed, if any, then extended till the next date of listing.
Item 22, my lord.
Give the list. Give the list.
I am giving the list.
My lord. Oblige. sir.
Lordship,
No, my item, my lord, it's come up tomorrow, my lord, almost.
Bench 490. What tomorrow or what? You have filed already or what?
Yes, only fine, my lord.
What is the matter
Matter regarding blacklist.
regarding?
Blacklist.
Lordship, item number 16 and 19, the
Hmm.
matter relating to that disconnect, we prayed for disconnection of the electric connection. The respondent filed their affidavit. In item number 19, senior counsel Ashok Saraf is appearing. Lordship, I pray that matter may be listed after 2 weeks, Lordship, both the matters, sir.
Affidavit has been filed or not?
By the department, Lordship.
They have filed.
Yes, they filed alleging some.
You'd like to file rejoinder or
Yes, I filed to rejoinder also.
item numbers?
16 and 19, Lordship.
The SC Learned Counsel for the petitioner submits that the respondent APDCL has, in the meantime, filed the affidavit in opposition. Full stop. He accordingly prays for some time to take instructions, file reply affidavit, rejoinder affidavit. Full stop. Para? List after 2 weeks. Is there any interim order?
No, Lordship, there is no.
This is item number
In 19,
16 and 19.
16, 19.
Oh. What about 17, 18?
17, 18, Lordship.
Item 17, I am appearing for Mr. M. Moore. He could not be present here as he is having a surgery.
Okay, we'll have it then together.
Okay.
You can inform him after 2 weeks.
Lord, as far as item number 18 is concerned, my lord,
Yes.
there is an application, interlocutory application for amendment of the restriction.
But since the main issue is connected, I think, or if you insist, we can have your application, issue notice at least, or whatever you say. Let it come on the same day, after 2 weeks, 16 to 19.
Where the lordship, my lord, these two items related to fair price shop matter. Since 2021, our shops have been cancelled, license have been cancelled at the behest of MLA. So it is urgent matter.
License cancelled.
No, it may be listed on.
License has been cancelled.
Yes, at the behest of MLA for no public complaint. So there is no.
You are
public-
challenging the cancellation.
Yeah. So it
Motion
may-
matter.
No, we have prayed for orders.
No, is it motion matter? Is it at the stage of motion?
No, it's the order, motion on notice have been issued long ago,
When do you want?
25/4.
Okay.
Oblige.
I have an urgent, make it 26. 25 is a Tuesday, make it 26.
26/4.
26.
I have an urgent mention for a motion, my lord.
When do you want?
Pertains to
When do you want? Tomorrow?
tomorrow or this afternoon, the unlisted motion.
What is the matter?
You know, there was a tender issued last year which was stayed by this court. Thereafter, for 1 year, the municipal corporation Bogaygaon did nothing. Then suddenly they issued an order and they issued a NIT also, saying that it would come up, you can collect the forms during the Bihu period, when everything was
Tomorrow.
closed.
Tomorrow.
My lord.
You filed or not?
I
Filed.
have filed it, my lord.
My pleasure, Lordship. Lordship, I beg to mention for listing a land acquisition matter, Lordship.
What is the stage? Motion stage?
No, or admission, Lordship.
What is the, it's an appeal or what?
Read petition.
Writ petition, land acquisition, what writ petition?
Actually, 50% amount is released and other dues are not released.
When do you want? Monday?
Next week, Lordship.
Next week?
Tuesday.
Tuesday, don't give it on Tuesday, have it on Wednesday,
Obliged,
not on a hearing day.
Obliged.
May I please, may I
I beg to mention, my lord, item number 34.
34 years?
My lord, the correction petition, my lord, has been listed for the fourth time today. Can it be taken up at 2 p.m., my lord?
34.
My lord.
34, I'll have it early, don't worry. Today there is not, matters are not much.
My lord.
May I please, your lordship, I beg to mention item number 25 and 26. 25, lordship, Mr. B. Over, who is conducting the case, he is out of station. And 26, instruction clarification is still awaited, lordship.
The other side has been
Yes.
informed
Yes, lordship.
on the
Yes,
prayer
sir.
made by Sri B. Chaudhary. The understanding council taxation department matters still adjourned by 2 weeks?
Yes.
What's it, 2 weeks?
I please, your lordship.
Yes.
Lordship, item number 20, lordship. This is
20.
item number 20, lordship. There is a no instruction for no coercive action. I have to take instruction, lordship. Instruction has not yet come, lord.
Inform the other side.
I have a
petition. 2 weeks
Lordship.
on the prayer of Sri P. Sharma, the understanding council AFDC. Matters still adjourned by 2 weeks to enable him to seek instructions. Para, interim order passed earlier, stands extended till the next date of listing.
Obliged.
Highly obliged.
My prayer for listing, my lord, on 25th, my lord. 20
Motion matter.
Motion matter.
Next week. 25th, not 25th, have we done 26th?
26.
25th is a Tuesday.
Obliged.
Also, I have filed one IA pending writ petition. So matter will be taken out 26, Lord.
I for
IA for staying one order
for interim order,
Interim.
21, 26.
26.
Have you filed already?
Filed, Lord. I have got the filing number.
Okay, okay.
High level.
May I please, your lordship, I would beg to mention item number 29,
Yes.
as my senior J-Roy is
Uh,
currently recovering.
Inform the other side.
We have informed the other side, your lordship.
It is, this court has been informed that Sri J. Roy and the senior counsel for the petitioner is recovering from some illness. Puts up para. List after 2 weeks.
Much obliged.
May it please your lordship. Lordship, I beg to mention item 25 of today's daily list. Lordship, in this case.
25.
Yes, lordship.
25 has been mentioned.
Mentioned. Okay.
2 weeks.
26
2 weeks.
is
25, 26, 2
Okay.
weeks.
obliged, Lord.
May I please, your lordship. I am praying for listing, lordship. Admission matter, the matter relating to
Motion matter.
admission.
Admission. What is the subject matter?
Subject matter, lordship, non-payment of contractual bill, lordship.
Okay, next week. Want to withdraw this?
Lordship, I have an instruction to withdraw.
P. and Sharma, learned counsel for the petitioner submits that he has instructions to withdraw this writ petition. Forest Department, anybody? Sri A. Barua, learned counsel for the Forest Department is present. Era, writ petition accordingly stands closed on withdrawal.
Obliged.
One.
Lordship, in this case, affidavit has already been prepared.
Yes,
Lordship.
yes. Lordship,
Lordship, in this case,
Seven. Okay.
Lordship, in this case, affidavits have already been prepared and since the matter relates to the Manipur, Lordship, concerned officers from Imphal is reaching today, Lordship. We'll be able to file it tomorrow, Lordship. Can it be taken up on Tuesday? Tuesday, let it be taken Tuesday, Lordship.
It is fixed tomorrow, my lord.
So till 10, my lord, it may be.
No,
stayed.
I am assuring, Lord,
no,
that
no.
if they file any adjournment, we will not object to that before the arbitrator. That I can
The
assure.
matter is before the arbitrator tomorrow.
Tomorrow,
Okay.
That I can assure.
Then you take,
That I
you
assure
give the
you,
advice, okay. Heard, B. Chakraborty, learned CGC submits that the affidavit in opposition is almost ready and can be filed within a day or two. Full stop. Three, T.N. Sayola, learned senior counsel for the petitioner, however, apprehends that since the date fixed in the arbitration proceeding is tomorrow, comma, any adjournment without considering the prayer of the petitioner may cause prejudice to them. Full stop. Para. Three, Chakraborty, the learned CGC, however, submits that the petitioner can pray for an adjournment, which he has assured that would be considered favorably till the next date. Para. In view of the above statement and undertaking, comma, matters then adjourned to be listed again on Tuesday next. But file it by tomorrow.
Lordship.
Okay.
Or
Because-
Thursday, Lordship.
Because Monday is a holiday.
Lordship. Then it Thursday.
Wednesday. Wednesday? Wednesday. 26. Yes.
It's, it is a lordships. My lord, it is a problem third round of litigation. My lord. Earlier, your lordships had directed my lord, the chief engineer, my lord, to allow the petitioner to deposit the additional performance security. My lord. Subsequently, petitioner went there and he wanted to express his willingness to deposit the additional security.
Public Works Department, who's there?
Yes, Sharma was there, my lord.
S. Sharma.
Big Goga is out of state. Probably S. Sharma will be appearing.
S. Sharma, who is S. Sharma? Public Works.
But,
Public Works, Mr. Who's there? B. Gogoi.
is out of it.
Nayak is there.
Supplied a one copy.
Nayak.
Oh, Pinac, sorry, my lord. I am sorry.
P. Nayak.
Pinac, yes. Because
Can-
there, my lord, I have supplied the extra copy of the.
Can you have his presence?
Will wait, man. I'll.
Try to get him. We'll have it after some time.
Well. All right.
He may be somewhere outside.
Probably, my lord.
Bigo and P. Nayak, PWD. PWD kun আছে? Dinath, yes, Dinath is also there. Various in S. Bora also. We'll try to have this in his presence. Try to locate him.
Lordship, in this case, the respondent side, they took time to file affidavit in opposition,
Have they filed?
not filed.
Who's for the respondent?
IOCL, your Lordship.
IOCL. What has happened today? Nobody is there. IOCL. What is your name?
A. Ahmed, appearing on
A.
behalf of
Ahmed.
Mr. ROC.
So, the A. Ahmed, learned counsel for the petitioner, is present. None appears for the respondent, in spite of the fact that time was taken to file affidavit in opposition. Full stop. The Ahmed, learned counsel for the petitioner, has informed that no such affidavit has been filed. Full stop. Para. Be that as it may, in the interest of justice, matter then adjourned by 2 weeks to give further opportunity. Is there any interim order? Yes, Mr. Nayak? Yes, what is this case?
My lord, may I invite your lord's attention at page 49, my lord. Outrightly, my lord, it will, my lord, face some.
40?
My lord. Page 49, my lord.
Hmm.
My lord, lordship order, my lord. May I read, my lord? Paragraph 3, third paragraph.
Ten days time was granted. Yes,
Well-
anything done?
Therefore, my lord, petitioner had expressive willingness, my lord, for depositing the additional performance security, my lord. But what happened, my lord, the ship engineer, my lord, he in adamant manner, my lord, he has injected, my lord. I think the one reason, my lord, kindly see the, my lord, speaking water, my lord. Page 51, my lord, last page, last paragraph, my lord,
Hmm.
last line, my lord. Intervention of this feature process will invite audit issue for tendering process as well as for accounting system. The bidder is not entitled to start physical execution of work without receiving notice of proceed with the work. My lord, here, my lord, this honorable court has specifically directed, my lord, to consider, my lord. And the petitioner has expressed his willingness also, my lord, to deposit additional permanent security. But the chief engineer is not accepting that, my lord. And earlier also, my lord, there was a direction, my lord, despite of the honorable court's direction, my lord, he had issued the tender, my lord, retender. There was also earlier round of litigation also, my lord. The chief engineer is doing all these things, my lord. And similarly, there's clear direction of this honorable court also, my lord.
No, court's direction was also only to consider. It has been done and rejected by a speaking order. The legality of the speaking order, you are entitled to challenge. But can we stay this order?
My lord,
These are ultimately matters of public importance.
my lord, that is why, my lord. Because, my lord,
We do not find an order of stay.
my lord, kindly see, consider one thing, my lord. The
It's not a
petitioner,
case for passing an interim order.
well, kindly
We
see,
can at best examine or issue notice and get the response from Mr. Nayak. But I don't think we should stay.
my lord, may I, read the, my lord, relevant paragraph, my lord.
Initially your challenge was on a different footing.
My lord,
Your challenge was not accepted by the court.
my lord, my lord,
Then you came up with another offer
my lord.
that at least for one work,
Yes, yes.
I am
that's
willing
right.
to give the additional performance
My lord, my lord.
security. And by the time they have already gone ahead.
My lord.
Now they have said that they are already gone ahead. We cannot force them.
My lord,
Mr. Nayak,
this objection was raised earlier also, my lord, and that considering that e-tendering, my lord, this court has observed this order, my lord.
let us have his response.
Lordship, kindly see page 51 of the speaking.
51, yes. We are at page 51.
Yes, page 51, Lordship.
Yes, yes.
Lordship may come in the middle portion, Lordship. In the meantime.
In the meantime, yes.
In the meantime, bidder again filed WPC number so-and-so, the earlier petition, Lordship, against which Honorable High Court ordered the department to explore possibility to reconsider award of that project, Lordship, 260 to the bidder, for which bidder agreed to submit.
Yes.
Then Lordship will consider. Department has analyzed and this sequence of developments on the issue of following facts. The department has so far performed and acted as per the provision of bidding document after the bidder's plea challenging additional performance security was dismissed by the Honorable Court. He was given time period to submit additional PS from 16 to 2023 to 25 to 2023 by letter number so-and-so. On failure, the bidder to submit PS and additional PS, the bidder bid security was forfeited on. Lordship, ultimately speaking order was passed in terms of court's order, Lordship. This is not under challenge, Lordship.
It's not under challenge.
No.
No,
not-
I have challenged this speaking order, my lord. I challenge, specifically challenge, my lord. Give me a prayer, my lord.
And four. Yes, Lordship, it is under challenge.
Challenge, my
But
lord.
Lordship will consider in the meantime, in the earlier, after cancelling his prayer consideration, after consideration, his prayer was cancelled, rejected. Then the corrigendum was issued, fixing new dates, Lordship. So my
Why
only,
didn't you give the additional security, performance security within the time specified? After
29,
this-
my lord, Yes, kindly.
After dismissal of the writ petition.
29-3, immediately, my lord, the order was passed on 27-3, my lord.
The
And
Lordship
here-
will consider one thing, Lordship. These rates are fixed as per the CPWD fixed rates, Lordship. In that CPWD rates, Lordship, 15% has already been fixed as his profit, Lordship. Now, if he submits a bid, Lordship, something less than 15%, Lordship, already he is in loss, Lordship. That he will have to compromise with the quality of the work, Lordship. That is the basic, Lordship. Lordship will definitely consider that point, Lordship.
There will be the quality. my
At the
lord.
very beginning,
There will
Lordship,
be
he is
everything.
at loss, Lordship.
No, that was not the subject matter. Subject matter was the requirement of giving.
No, why
Petition-
no,
No, that would have been, this submission of yours would have been relevant in the earlier round of litigation, which we have already taken care. Now, by the last order, we have said that we are not accepting his prayer, but we remanded the matter to the authorities because we have reconsidered past the speaking order. At best, we can examine this, cannot stay this.
My lord,
Heard Sri Asok, Learned Counsel for the petitioner who has put to challenge an order dated 10/4/2023 passed by the chief engineer, PWD, within bracket border roads,
water.
border roads. Full stop. The said order has been passed on a representation by the petitioner and in accordance with a direction of this court in an earlier round of litigation by the petitioner. Full stop. This, the records reveal that the petitioners, that the subject matter, that the present case, which is an offshoot of the earlier petitions, is with regard to performance security and additional performance security, whose imposition was the subject matter of challenge in the earlier writ petition, which was rejected by this court. Full stop. Thereafter, it appears that time was granted to the petitioner to make the state deposit, which however was not done in time, on the ground that there were sufficient amount of the petitioner which he was entitled from the department, and the same could be adjusted. Full stop. Para. The order which has now been passed on 10/4/2023 has rejected the prayer of the petitioner to allow him to submit the performance security and additional performance security on certain grounds which have been enumerated in the speaking order. Full stop. Para. Issue notice returnable by 4 weeks. Pre Nayak, Learned Standing Council,
PW
Public Works
1, 2, and
Department
3.
accepts notice on behalf of respondent numbers 1, 2, and 3. Yes, central government, pre-SK Methi, Learned CGC, accepts notice on behalf of respondent numbers 4 and 5. That extra copies of the writ petition be served upon the Learned Council for the respondents by tomorrow. Para. Any heard the Learned Council on the interim prayer, full stop. So this under the facts and circumstances, this court is not inclined to pass any blanket order of stay of the impugned order. Full stop. However, it is observed that any action taken pursuant to the impugned order would be subject to the outcome of this writ petition. Yes, next.
Obliged, my lord.
And Busso, T. Chaudhary. T. Chaudhary was here, Gautam Chaudhary. What is the matter about? Who is on the other side? A Borkotoki, P Bharadwaj, I think Oil India is there or what? Who is on the other side? For the private respondent, not Oil India. Who are the respondents, madam? No idea. You should have the brief. If you appear, have the brief with you. If you ask something, you can at least answer the question. Where is your senior?
Senior, the court,
Other side is also not there.
court number.
Mr. Borkotoki, Bharadwaj. Yes, after some time, try to have a look at the other side also. If if they are not there, then we'll have it on another day. Try to look at them. Yes, next. Mr. Jalan, which case?
Well, this is regarding a non-renewal of the registration certificate by the Registrar of Societies in view of the amendment made in the 2019. But subsequently, my lord, that rider which has been made that beyond 1 year that cannot be due has been taken away by further amendment of 2022. And to that effect, my lord, the respondent authority has filed their affidavit. They have admitted that if the online application is made, it can be considered.
Has it been considered now?
No, no, madam, it is still not considered. Because
Madam,
if your
are you
lordship
appealing?
kindly
Are you
tell us, my
appealing,
lord,
madam?
one more thing, madam. If your lordship kindly peruse the MP in order 45.
Hmm.
They have also called for certain inquiry report from the deputy commissioner, which this petition I made in the respondent number 3. So far as this rider is concerned, there is no issue. But this report is not forthcoming. My application is pending since 2015, and to that effect, my lord, kindly peruse page 28, my lord, of my writ petition, wherein in the year 2015 itself, my application was made on 18/3/2015.
Who is respondent number 3?
3 is the deputy commissioner Karbianglong.
And 5?
5 is the, my lord, 5 is the ST Karbianglong. He has no role, my lord, because some criminal cases were filed against some few members. There was no complaint against the NGO as a whole, against the society as a whole. And those complaints were my lord, terminated in-
These two respondents have filed their affidavit.
Yes, my lord. They have filed. 3 and 5 as
3 and 5.
Yes, my lord.
3 and 5 months.
So, my lord, only with this observation, this writ petition can be disposed of, that the deputy commissioner will make the inquiry and file the report, and on filing of the report, within a time frame, the
What do you say,
application will be
madam?
considered.
He applied,
We
my
are-
lord, in 2015. Let him apply online, my lord.
Yes, I will apply, but I will apply, ma'am.
And it will be considered. That's the stand in the affidavit, my lord. Paragraph 10, page 59. Lordship is brief.
By the MP order, they asked for certain inquiry from the DC concerned. The DC may be directed to make the necessary inquiry and file the report, and within a time frame, my application on being filed online, that may be considered. With this observation, this.
What about the police cases against some of the
No, no,
members?
this has been culminated in filing of FR, and in one case, the 2 of the members has been, they have been acquitted. I have
What
annexed, my
was
lord.
the charge?
They are under 420/468, my lord, but that has been, he has been acquitted. Those 2 members have been acquitted, and in one case, FR has been filed. My lord will kindly peruse page 30, my lord, of the writ petition. That is the order passed by the learned magistrate.
Then we pass a direction for consideration of his online application
Lord,
in view of the amendment of the act.
lordship, that's it.
Heard. Jalan, Senate Council for the petitioners. Also heard MS S. Sharma, the Learned State Council. Full stop. As agreed to by the parties and considering the dispute involved, comma, this writ petition is taken up for disposal at the admission stage. Full stop, para. The petitioner, number 1, is a registered society. Please have your seat.
Right.
Society under the Societies Registration Act 1860 and was last extended up to 24/10/2014. Whereafter, continue, sir, full stop. Whereafter, comma, the petitioner had applied for renewal and the process of renewal was on, full stop. However, comma, at that time, some criminal complaints were lodged against three members of the petitioner society, which was registered in the Diffu police station. Full stop. On such, in view of such development, comma, the registration of the petition number 1 was not renewed. Full stop. It is the case of the petitioner that the criminal case had ended up in a final report, which was accepted by the court.
One in final report, one in acquittal.
That the criminal cases had ended up in final report, acquittal. And therefore, there is no impediment in consideration of the renewal of the registration, full stop. The Sri Jalan, the learned counsel for the petitioner, has submitted that though in the intervening period, due to the amendment of the Societies Registration Act, within bracket Assam Amendment, 2019, the renewal after expiry of the validity for more than 1 year cannot be permitted, there has been further amendment in the Act by in the Act, more particularly, Section 3C and 3D.
Yes, my lord.
3C and 3D by an ordinance of 2022, whereafter renewal is permissible on payment of a prescribed fee, correct? For the period when such renewal should have been made till the date of expiry. No, from the date of expiry till the date of filing. Full stop. Sri Jalan, the learned counsel, submits that the petitioner number 1 is therefore eligible to apply for renewal under the amended provision, which is required to be considered by the authorities. Full stop. Para. MS Sharma, learned counsel, learned state counsel, by referring to the affidavits filed by the respondent number 3 and respondent number 5, has submitted that there is a candid admission that if an application is made for renewal of the registration, the same would be considered in accordance with the amended provision of the Act. Full stop. Specific averment to this effect has been made in paragraph
10, my lord. Page 59.
10 of the affidavit filed by respondent number 3.
Lordship.
3, which is extracted herein below.
Last line, accordingly, the society may apply for renewal online with uploading all the necessary documents and on receipt of online application.
Yeah. 59. Para. after hearing the learned counsel for the parties and taking note of the expressed stand of the respondent as recorded in the affidavit in opposition dated 21/2/2023, this writ petition is disposed of by giving liberty to the petition number 1 to apply for renewal of the registration by online application within a period of 2 weeks. 2 weeks from today. And on such application, the same would be considered. Term is directed to be considered by the respondent authorities and pass appropriate orders in accordance with law.
Observation
Such-
also be made.
Such orders may be passed within a period of a month from the date of receipt of such application.
Page 20 of the report submitted by the DC at that relevant time when my application was pending, that may also be considered.
We file a fresh application.
Fresh.
I will make the first application. So far as the report, they had the impugn order, they had also called for the report from the DC. They are not forthcoming. So already there is a report, my lord, since the date of pendency of my application.
Now, after the amendment, there is no impediment. Why are you going to the decision
No, this is
report?
also one of the requirement. Inquiry report from the DC also. An exam for may also be considered.
And at this stage, Sri Jalan, the learned counsel for the petitioner, points out that there is a report from the
Report
Concerned
dated 17
deputy-
February,
there is a report dated 17/2/2015
17 February 2015.
from the concerned deputy commissioner. Full stop. The said report may also be considered while considering the application of the petitioner, number 1, for renewal of the registration. So, writ petition accordingly stands disposed of. Yes, next.
Obliged. Please.
Kindly, Mr. Chaudhary.
My lord. My lord, this is that matter, my lord, regarding my lord, that mutation which was not done. And my lord, then application was submitted that there was a degree of the court, my lord. Subsequently, that notices, my lord, that case record could not be, my lord, traced out. And my lord, there is a report from the civil judge saying that case record itself, my lord, is missing. That is not there. That was pursuant to a direction of this honorable court to conduct an inquiry. My lord, that application for, my lord, that case record was done on the basis of the initial written objection which was filed against the grant of mutation in my name, my lord. There, my lord, the respondents, they have come up with an objection saying that there was a decree. But then, my lord, later on, when the records of the, my lord, deputy commissioner was called from this honorable court, my lord, it appeared that, my lord, there was some other objection where, my lord, that the fact of the decree or other things were not mentioned, my lord. So, my lord, now at this stage, my lord, perhaps the matter may be then remanded back to deputy commissioner to, my lord, settle, my lord, and to, my lord, pass the mutation orders under the rules, my lord, and the regulations. Without, my lord, being influenced by the fact that there is a decree, my lord.
Objection, my lord. It's very right now by but today I missed the matter and I'm briefless. I can take this. I can tell you.
No, we can have this on this. If that is his submission, we can have this for disposal on Tuesday.
My lord.
You come with your file on Tuesday. Your names have been shown.
I missed the item because the items sitting this also our names are shown.
It happens if you have too many cases.
Sorry.
There are ways to reduce cases. That's it.
From the senior Mr. Chaudhary, it ought to come back to the junior Mr. Chaudhary. my lord.
No, he is on the way. In between, he is there. It has to percolate through him.
Well, even then, my lord, that order can be passed today also, my lord, if your lordship pleases, my lord, because now that, my lord, only thing is that, my lord, the deputy
We'll
commissioner.
do
will
after
not
some time.
be-
You do one thing. If you have the court's second copy, or you can have madam's copy, just go through it.
Acquainted with the facts, Manoj.
No,
I
but,
just want to place the entire thing in a chronological order and I have certain documents in my brief.
We'll have it on Tuesday. Don't worry. You're there on Tuesday.
My lord.
On the Sri G. Chaudhary, the counsel for the petitioner submits that in view of his amended prayer, the writ petition can be disposed of with a direction to the deputy commissioner to reconsider. Full stop. However, Sri E. Bharadwaj, Learned Counsel for the private respondents, submits that due to some personal difficulty, he is not, the matter may be, and the difficulty on his part, the matter may be adjourned and may be listed in the next week. Full stop, para.
On 26.
List on 20, we have on Tuesday itself.
No, he said, "Madam, we have some difficulty on."
Okay, on 26th. List on 26th.
And you provide.
No interim order is there.
No.
Review. Finally.
Page 70 is order of this number.
Mithun writes, Mithun's surname is Paul.
Yes, ma'am.
We thought it was Chakraborty.
Yes, yes.
And he's a PhD also.
Yes, ma'am.
Dr. Saraf, what is the surname of Mithun? Chakraborty. He writes Paul. And he's changed his profession
Yes, ma'am.
from an actor to a lecturer.
Yes, yes. Ma'am.
Yes. What is the review?
In page 70 of the order of this noble court, my lord.
Page 17.
70, my lord.
70.
Yes. Before it, my cases, my lord,
I think we'll take this for final disposal today. This matter has been coming on a number of times.
Yes,
due to paucity of time, we're not being able to take up.
The records of the, my lord, of Director of Higher Education is with the cost of Gugoi, my lord.
Is there? Oh.
But they file affidavit, my lord, and in particular affidavit, they.
So who will be representing the higher education? He is not there today. Mr. Medhi will not be proper.
Yes, I understand.
Will not be proper. Otherwise, we thought they will take up the case.
Yes, ma'am.
Let his presence
Yeah, I
be there.
understand, ma'am.
No, Madhurar? Let his presence be there. Okay. But today we had the proper time also.
Yes, ma'am. Yes, ma'am. Yes, ma'am. So my client, my lord, isn't been very well. Because my learned friend client, my lord, is OBC from West Bengal. Ma'am. It was submitted at the time of.
He can go to Navagraha. Make some.
Yes.
There is some problem with his planets.
Yes, ma'am.
Today we had the time and council is not there. I think 3-4 times the matter had come up.
Yes. But the day affidavit is filed, my lord, mentioning that he subsequently filed it.
Those three SK Methi Learned Counsel for the applicant, as well as three FZ Mazumdar, Learned Counsel for the contesting respondent number 6 are present, this court has been informed by MS PR Mohanta that the higher education department would be represented by Sri K. Gogoi, who, could not be present today
Good evening.
due to some medical reasons. Full stop, para. Can we fix a date?
Yes, my lord. Second of May, madam.
After 1 week. In that view of the matter, let the matter be, in that view of the matter, let this petition be listed on
2nd of May, madam.
2nd of May. Is it okay, madam? 2nd of May.
Can it be on the second week of May, Lordship? In the
2nd week of May.
any date, Lordship?
9th of May. 9th. Tuesday. We'll try to have it.
My lord, after Navagraha, madam.
Before.
This is the matter relating to the.
I was supposed to file an affidavit which they could not do.
On the last date, my lordship
Can I
made it very
take for
clear.
2 weeks' time?
Lordship made it very clear, my lord, that if the affidavit not filed by the next day, then the lordship will consider the interim period. Lord, lordship, see, what is the interim period? I mean, in fact, the petition can be disposed of. What I'm praying for, that whatever materials are there, that should be given to me, and thereafter you pass the order. I'm not asking for anything else.
Don't let our affidavit come on record.
No, your
after that.
affidavit may come to the court, but whether I'm asking for a relief
For interim consider filing of the returns. But this is the second date.
No, Lordship.
Effectively, this is the second date. But yes, you're also correct that we had made an observation that is to ensure that the returns were to be filed because your interim order was deferred for consideration till today. What is the nature of the interim order you're praying?
Further, my lord, the
One thing, my lord, I want to clarify.
So we'll come back to
The
you.
moment your lordship gives an interim order, the NCLT matter will be held up. Because they will be.
my lord, if I'm insolvent, then how can we?
No, you have said that you're,
Well, then how
Prince-
can we willful defaulter?
no, Mr. Dr. Saraf, you are saying that you are praying for some innocuous kind of an interim order. What is the interim
I said that, my lord, the further proceedings in pursuance to this order should remain stayed.
in the NCLT?
No, in this, the willful defaulter,
That.
willful defaulter, I'm not saying how it can be held a bearing, my lord, your lordship, can I see?
Therefore, my lord, let my. affidavit
My lord, that
come out
was a
that our
company-
Lordship can decide
No,
that.
no, the company has gone in the, my lord, insolvency. These are the directors. They have no insolvency proceeding has been initiated against the directors. If my learned friend that says that the directors are insolvent, then there cannot be willful defaulters also. Because if they are insolvent, then when the question of defaulter. Now, my prayer is there in the petition, my lord, that certain documents and papers which were there, that were not given to me, certain statements which were given that has been not considered on the ground that they were not CS certified. My prayer is that not that these documents were given to me and they are.
But your content, your challenging against the, or that the order passed by the review committee.
Yes, my lord.
It was already decided against you by earlier also.
Just 2 weeks.
that has
time,
to
my
be-
lord, after that, your lordship, hear the entire.
And the similar cases I submitted before loss of judgment, similar case, my lord, which in Bombay High Court also came, where it was referred, my lord, demanded back to the my lord that you give the papers and documents, pass the order. If you are not satisfied on that, you can pass the order, all
How
the.
soon can you find the affidavit?
Just 2 weeks time, my lord.
2 weeks time. It was listed on 27/3. Today is 20, almost a month. Had Dr. Saraf, learned counsel, senior counsel for the petitioner, who by referring to the order dated 27/3/2023 has submitted that the consideration for interim prayer was deferred on the request made on behalf of the bank with the assurance that the returns would be filed before the next date, that is today, full stop. However, no returns have been filed, and therefore the learned senior counsel to the petitioner has submitted that the interim prayer to stay the proceedings for declaration as what?
Willful defaulters.
As willful defaulters should be stayed, full stop. On the other hand, Riyaz Datta, learned senior counsel for the bank, has submitted that such an interim order would also affect the NCLT proceedings, the proceedings in the NCLT Guwahati. Full stop. He said he further prays for 2 weeks time. By 2 weeks time to file the affidavit in opposition. Full stop. Dr. Saraf has responded by submitting that the interim order prayed by him does not have anything to do with the NCLT proceedings. Full stop. Para. Considering the rival submissions and balancing the equities, this court is of the opinion that the interim prayer would still be open for consideration. Would be considered by giving a last and final opportunity of 10 days to the respondent bank. It is, however, made clear that if no returns are filed, the interim order would be considered without such returns. Full stop. List this case on 10 days. On.
First week, madam.
Give us a date.
So the 10th of May, my lord.
We'll have it on 5th is a holiday. We'll have it on 8th of May. Eight. Adhiki Mantri ko. Visi din. You are getting mood is.
Letting me, my lord, letting me satisfied so that he may at least
You are getting more than 2 weeks.
be getting more, much more.
On 3rd of May.
Well,
Third, my lord, I'll be out of.
you file the affidavit. If you are not there, let us, you file first.
No, filing can be done, but if.
You first.
Third, my lord,
No, no,
I'll-
before third, let you file it.
Mr. Datta wanted to say that something which has been given should not be taken away. Now, since 8th was already declared, it should be there.
It keeps.
8th.
Much of that.
Legitimate expectation. 8th.
In fact, my
8th
lord,
May.
even if, my lord, we agree, sometimes we agree with the, by friend, by request. But now we cannot agree also. Personally, my lord, because the live telecast is going on, so I have to oppose, my lord.
Very clever.
Don't be too much bothered with live telecast. Let us have the same atmosphere in the court.
Because earlier we used to have some difficulties there, we could have agreed, and now I'm obliged, not
Somebody is observing.
observing, not observing, but it remains in record.
If you are bona fide acting, why should you be concerned with the observation?
Yes.
No, no, the timing of time, last time we had observations were made, that the entry would have passed. So, and my learned friend, 1 month, he's so concerned with the money and all those things, the bank, and they are not bothered.
Okay, next time.
Yes,
My lord.
obliged.
We'll have to take this up at 2 o'clock. Yes, what is the nature?
My lord, in the next case, my lord, I prayed for a correction of the lordship order, my lord. Two repetitions were disposed of.
Jamindari case.
Jamindari case.
Yes, what has happened now?
Two repetitions were disposed of together, my lord. But the affidavit filed by the respondents, my lord, they mentioned the same case numbers in both the repetitions. So,
No,
my lord,
one, I think we have modified one.
yes, my lord, they have filed an affidavit. They have filed an affidavit.
No, we modified one of the cases.
Oh, my lord. The lordship directed to file an affidavit, my lord. The respondents, my lord, clarifying their stand.
No, one case, I think, the vigilance case, isn't it?
Yes.
One case we have modified.
So, lordship has disposed of two cases together.
No, is this the first case? He had come up for modification.
Yes, my lord. So listed earlier also, my
Hmm.
lord. Lordship directed them to file affidavit. They have filed an affidavit
No, that was
clarifying their stand.
some 6-7 cases which are mentioned by them are not part of your cases.
My lord.
Where made a clarification?
So in
In
this
which case? Remember distinctly.
lordship picks up their affidavit, my lord.
You are referring to the IA
Yes, my lord.
474.
Yes, my lord.
Tell us what is it? What is it?
My lord, two repetitions were disposed of by your lordships together.
Now, in this petition, IA, what do you want?
I am, my lord, praying for inserting the case numbers involved in the present collected repetition.
Okay,
Yes,
agreeable
my
to
lord.
you. Where is the order?
We'll find the order at page 9, my lord. That's from page 9.
Operative portion.
Body portion is, my lord, page 13. my lord.
Yes, which?
Page 13, paragraph 5.
Hmm.
Lordship has mentioned the case numbers of the repetition, but in both this is the case numbers of one repetition. Other case numbers lordship find in the affidavit as well as the
Present affidavit in the IA.
my lord.
Where is the IA? Where is the affidavit?
Affidavit page 18 of their
Is paragraph 4.
paragraph 4, 5, and 6. They have clarified, my lord.
No, the case numbers.
6 will do, my lord. Paragraph 6 will do,
6 will do.
my lord.
Okay. Third, 3IH Taikya, Senate Council for the applicants, public writ petitioners. Also heard MS PR Mohanto. and Standing Council, Revenue Department. Full stop. This application has been filed for correction of the order dated 8/2/2023 passed in the connected writ petition 6279. Is it 6279? 6279 2021. Full stop. The facts in the writ petitions. The projected facts in the writ petition was that the petitioners were joint tenure holders of various estates covered by various taluk numbers, which were acquired by the government of Assam under the State Acquisition of Jamindaries Act 1951, bracket hereinafter referred to as the Act, bracket close. After such acquisition, the compensation was assessed by an award which had attained finality. And since the amount involved in the award was not stayed, this writ petition, a writ petition was filed by the petitioners, in which there was an order to examine the claims of the petitioner. Full stop. The said order of this court was also not complied with, leading to filing of the present case. Full stop. It may be mentioned that along with the said writ petition, along with the present writ petition, another writ petition by 4 numbers of petitioners was filed, being WPC 6281/2021. Full stop. It appears that in one of the writ petition, the department had filed an affidavit wherein, though a reference to certain cases taken up by the Vigilance Department was mentioned, in paragraph 4 of the said affidavit in opposition dated 13/12/2022, certain cases were mentioned which were not in the list of 57 numbers of cases which was within the ambit of the investigation by the CID. Full stop. In the order dated 8/2/2023, the aforesaid paragraph 4 was quoted. Full stop. Sri Saikya, the learned counsel for the applicants, has however clarified that in the affidavit filed, the case numbers mentioned in paragraph 4 was incorrect, incorrectly put.
But it was correct in respect to the other petition.
Was pertaining to only the other writ petition, namely WBC 6281/2021. And in absence of a separate affidavit, the state case numbers have been reflected in this, in the order dated 8/2/2023, which was a common order, correct? Full stop. Common order passed in both the writ petitions, 6279/2021 and 6281/2021. Full stop. Three. Thank you. The learned counsel for the applicants has further submitted that in the present IA, the department has filed an affidavit by which the matter has been clarified and the stand taken by the petitioner has been endorsed. Full stop. In paragraph 6 of the endorsed, full stop. The Sri Sakya, the learned counsel, accordingly submits that necessary clarificatory order may be passed by modifying the order dated 8/2/2023, full stop para. MS Mohant of the Standing Council Revenue Department has fairly submitted that the quotation in the earlier order regarding paragraph 4 pertains to the other writ petition, which has been clarified by the present affidavit in opposition present affidavit filed on 6/4/2023. Full stop. Full stop. By drawing the attention of this court to the averments made in paragraph 6 of the said affidavit, the learned counsel for the department has submitted that so far as the present writ petition WPC 6/2/79/2021 is concerned, the concerned cases are mentioned in the said paragraph number 6, which is extracted as herein below, paragraph 6 at page 19. Full stop. After hearing the parties and on perusal of the records, the IA accordingly stands allowed by treating the original order dated 8/2/2023 to also include the cases referred in paragraph 6 of the affidavit, which has been extracted above, to be in respect of the present WPC 6/2/79/2021. Full stop. I accordingly stands disposed of. For all practical purpose, the present order is required to be read as a part of the order dated 8/2/2023, as a part of the common order dated 8/2/2023, passed in both the writ petition. I accordingly stands disposed of.
Deep level.
Yes.
Lordship, the respondent number 5 is a Swedish company. Enter into an agreement with the National Highway Authority for the construction of the 4-laning of the National Highway from Jorhat to Jhansi. And that Swedish company, Lordship, with the due permission of the National Highway Authority, entered into a subcontract with the present petition, and which was duly approved by the National Highway Authority, NHIDC. So contract of the petitioner was a subcontractor, Lordship, was duly approved by the National Highway Authority. And the present petitioner, Lordship, completed the construction of the National Highway from Jorhat to Hajipur lane. And the bills were submitted. But finally, it is found that the main contractor, that is the Swedish company, Persian respondent number 5, fled away from India without doing any work. He even did not work even inch of constructed inch of the national highway. That point is also admitted by the NHIDC, that the main contractor did not execute any work and he never mobilized his workers or engineers, Lordship, and did not bring any message. So there is no dispute regarding that. The petitioner completed the work. And when the main contractor, Lordship, did not execute the work, Lordship, his contract was terminated. And the work value of the petitioner is almost rupees 11 crore. And that amount has not been paid to the petitioner. Here, Lordship, we are pleased to consider that petitioner is a MSME unit, Lordship, covered under the provisions of the MSME Act 2006 and rendered services to the NHIDCL. So he is entitled to get the payment within 30 days from the date of completion of the work or from the date of submission of the running bill. That has been also noted. The NHIDCL, Lordship, in their affidavit in opposition has admitted that the present petitioner has executed and he is entitled to pay. But they have taken the NHIDCL authority, Lordship, taken the plea that there was no contract with the subcontractor. Hence, the NHIDCL not bound. So, Lordship, my argument will be based on section 70 of the Contract Act, that the act was not correct. And the petitioner is entitled to. That will be the 1 point. And other will be, Lordship, it is a small scale industry is under the MS Act. Under that act also, he is entitled to get the principal and the interest. The other aspect is this, Lordship, the agreement itself shows that whenever a subcontractor is approved by the NHIDCL, it will be deemed to be a main contract.
Deemed to be a?
Deemed to be a main contract.
Main contract.
Main contractor. And other main point will be, Lordship, whenever a subcontractor is appointed by the main contractor with due authority with the NHIDCL, Lordship, the subcontractor becomes a assignee. And the assigner seizes his right law. That is well settled law. And it is the assignee who is entitled to get the payment. The Lordship, maybe pleased to come to the contract which was executed between the NHIDCL and the Swedish company. That Swedish company, subsequently, it was declared insolvent by the Sweden government, and Lordship, the notices were sent to the Swedish company, but it was served also, but they did not agree. Lordship, I am pleased to come to page 21, Annex 4. This is the contract agreement. And your Lordship, me pleased to come to
Mr. Secretary, for whom? No, you're with you, means. He's with you. Anyone from the Swedish company?
No. Notices were served, nobody. That company becoming.
What is your difficulty? We'll come back to just. Now, Mr. Roy says that you have admitted that the work in fact has been done by the petitioner. We are not going into those aspects whether your approval will change the status from a subcontractor to a main contractor. Those can be matters of debate. But if you're admitting that the work has been done, can you hold back the payment only because there is some outstanding by the Swedish company? But because you have to leave the veil, if you know it is within your knowledge that Mr. Roy has worked in place of Mr. somebody else, then completion of the work is also no problem. Bills to 11 crores is not a small amount. And we are also not even going to the aspect of MSME. He will get some advantage. But is it not reasonable for him to ask for the payment?
That he has executed some portion.
No, in these matters of this kind, don't you think that instead of a very rigid approach based on technicalities, should work it out because somebody's fault, he should not be made the victim.
But what happened here, my lord, that the
No, we
company-
can apprehend, we can anticipate what would be falling from you. That there would be some outstanding from by the Swedish company. Maybe this 11 crores will not be enough. Maybe much more you have.
Now,
They have
9 crores
fled away.
are dues.
Huh?
9 crores and also we are receivable from that particular company.
Yes.
From that. After adjustment of all this amount, performance guarantee, everything.
But those are not related to this work.
No, Lordship, there 2 works were allotted to the Swedish company.
These are related to some other works, not the one.
Yes, one was from Jora
No,
to Haji.
we are not finding fault with that. You are entitled because you are dealing with public money.
Public money.
For you, that is also no less important. But at the same time, his entitlement as a citizen, he has worked with the expectation, minimum expectation that he will get the returns. And you have admitted about the work done. Somebody else, unless you can show some kind of a connivance between him and the Swedish company, which perhaps is not there.
But if his claim was against that particular company, perhaps the NHIDCL would have supported him for recovery his dues from that company. But here,
The money would come from you. Maybe it would be routed through the Swedish company, but you are the source. You may be absolutely correct that you may not recognize him. You recognize the Swedish company. He gets the money from Swedish. Once you give the money to a Swedish company, your liability comes to an end. And you are not too much bothered whether he gets or not. But lifting the veil, you have admitted that he is the subcontractor. You have approved your contract itself provides, unlike most of the contracts, this provides for subcontracting.
Yes.
It was done, it was approved. Moment you have approved, you have recognized him, given him some kind of recognition. It's not that you don't know Mr. Roy, you know him.
Yes.
You also know that the work has been done. Money involved is 11 crores. Can you hold this back? Will it be proper?
My lord, authorized engineer of the NHIDCL recommended that the entire work has been done by the present petitioner and his bill should be released. Under the contract agreement and as per the National Highway Lordship, authorized engineer is the only authority, Lordship, to prepare the bill and recommend for the payment.
Is there any connivance you have pleaded in your affidavit?
No, nothing. In affidavit, opposition Lordship, very small. They have clearly admitted, not only
Your works, neither in this was completed, nor in there it was completed. Both the works were half done.
No. We are not on the entire.
Cancel both the
We are not on the entire works. The works which were subcontracted to the petitioner. 11 crores, you have admitted that he has done works of 11 crores.
My lord, we don't say that 11 crores to.
How much? How much do you say?
My lord, what we say, my lord, the 30% works have been completed. Out of the wherein, my lord, his work is also included. And from this contract, the company is to receive about 11 crores and odd.
Now, is the work
these
done
are-
by, is the work on your question, on your reply only, I'm asking, connected? The work which he has done or which this case is, has been filed before this court, is it, is the amount of the work 11 crores, the entire amount, or is it less than 11 crores?
But he has executed.
You said that the company has executed in total works of 11 crores. Out of that, see, you said 30% you have said.
11 crores after, my lord, the adjustment of everything, my lord, in this particular contract. 11 lakhs and odd were to be payable to the company, the contractor.
11 crores.
Plus 11 crores or 12 crores or not.
No, is what is the value of the work done by the petitioner? Have you worked out?
Yes, well, that was
They
something
stated in para 11 of the affidavit.
26 crores.
They have clearly admitted in para 11 of the.
How much is your due claim here?
My claim, Lord. Yes, Lordship, 11 crores, 6 lakhs 85,700.
Now his crores is confined to 11 crores.
Some amount he has, it is not that much, he did not receive any amount, he had been receiving.
No, I did not receive a single penny.
On the date of, my lord, it was, my lord, what, on the termination of the contract, we have worked out the, my lord, the valuation. But he had to receive and what, my lord, they have to, my lord, pay if any damages.
See, you say there are two contracts with the same company. He was given subcontract with regard to one work or two works.
One work.
One work.
Jorhat to Jhansi.
Jorhat to Jhansi. We are not concerned too much with the other work. Let us confine our discussion to Jorhat to Jhansi, where he is involved. So as a subcontractor, he was given the work, right? And that subcontracting was approved by you because it is admissible under the present contract, Annexed 4. And now you also admit that the work has been done by the petitioner as a subcontractor. He has not been paid anything. Now, after on those circumstances.
Subcontract approval is also with certain conditions. Approval itself. With certain fault done by the subcontractor. That will be presumed to be the fault of the contractor. So
No,
anything receivable
those I think points may not be very relevant here.
There is no such averment in the affidavit of Vishal Lordship. They have immediately admitted clearly.
There would be certain points, Mr. Sekya. Suppose you say that the quality of the work is very poor. So it did not even last the quality check period. Those are not the case. It's a simple case of work done, payments not made.
It is delayed, and thereby the cost of mostly of the partner.
Have you lived with the LD?
There is no such averment.
Is there any provision for levying of LD, liquidated damage?
Yes.
Did you work out the liquidated damage? You have not worked out.
Things have been worked out. Even the termination, the order of termination.
Then that is what we are trying to extract from you. What, according to you, would be the liability? Would be his claim? Let us forget 11 crores.
We do not have any total of contract, privity of contract with him. We have nothing to do with him.
Okay. Let us assume that he has not done the work. The Swedish company has done the work.
Yes.
Let us forget that there are liabilities, other liabilities.
Yes.
How much work the Swedish company has done? And if you have imposed LD upon the Swedish company, what would be the amount involved now?
Now, one.
451. 451. Yes. Hmm.
451 people. Sure.
The response number 5
See,
was
the works are entirely different. One is Jorhat to Jhaji, which he is concerned, and the other is Jhaji to Dimo.
demo.
You are not connected. Jhaji to Dimo, you are not
No,
connected.
I am-
You are only connected with Jorhat to Jhaji.
Both have been cancelled.
Cancellation is okay, but he is only claiming that for the works done by him, payments are to be released.
But how contention in the various pleadings here.
Now you tell us, how do you do justice to him? You are not saying that he acted in connivance with the Swedish company. They fled away, then also he is taking the money.
His remedy against that company with whom he has entered into a separate subcontract marriage is governed by that. And the way we have in the affidavit, we have said he has executed his part of the work. We'll definitely support those content any a claim raises against. We are not, will not deny that he did not work or etc. Support in that way, but otherwise now
That is a very easy way out.
we have to recover.
That's a very easy way out. If that was the way, then we would not have deliberated so much. But
They are
is-
using the toll plaza has been installed, they are collecting the taxes.
But is that a reasonable solution? A Swedish company, foreign company, we are not saying this is not possible. It's a possibility, but will it be proper? Where the national higher authorities are involved.
But that was for him to decide.
He'll
while
spend years
entering-
together only to
entering
get the
this
service done.
was for him to decide choose the whether to enter into the subcontract or not. Because we are concerned, we have made sufficient clauses by which the public.
See,
money,
at the time of
is-
entering into the contract, did you expect that the company from Sweden will vanish?
That was never expected.
So why are you finding fault with him? He is nobody in front of you.
I understand, but only thing is
National
that
Highways
we
have done all the due diligence, entered into a contract with a company which vanishes, and you are trying to say that why did he enter into a contract, subcontract?
Since deliberation has come up, so I am saying otherwise, I have not.
No, we have to be reasonable in our thinking. How see, our line would have been different if you had raised an objection that the work was not done or not properly done. There is no such objection. There is no objection of any connivance.
No, it is not.
Whether NRJDCL praised the present petitioner that he has completed the work very nicely. Having all the competency, machinery, everything, though all these annexures are on record. Amount is admitted. Authority engineer directed the director to pay the bill of getting DECA.
The details we have given this. Now we are to recover 9 crores 31 lakhs about after adjustment of all this thing, also public money. We have to pay the amount what he pays. Because this will further the
9 crores under what head?
We'll go to about 20 crores.
9 crores under what head?
After this final valuation after the termination of the contract, there are clauses.
The 9 crores are penalty or liquidated damage or what?
Liquidated damages, including up to demo.
The calculation already given in the final termination.
So recovery from a contractor would only be in the form of liquidated damage for some fine or imposition of fine. The money otherwise normally have to be paid by the owner for works done. And you can impose certain cost or fine upon him only because of non-performance.
Various heads have Permission order itself. It's something. That is permission.
Permissible, we are not entering into that arena. What is permissible under the contract? Yes, you are permissible. It is permissible. You are permitted to recover certain things. But this is something which she is claiming against works done.
What was done for him, the effect. That's what my thought, I cannot go beyond that, my lord, pleading what we have.
I think you should reconsider this case. Have you considered?
My lord, they say, my lord, that they have filed an application for arbitration or conciliation. But then we not received that, what we said.
No, we did not file. Respondent number 5 filed, but nothing was done by the NHS.
Who is 5, respondent 5?
That Swedish company. He has demanded arbitration law after termination. But there was no answer from the NHS. Your Lordship, the contract itself, my approval, Lordship contract itself discloses that Lordship, the subcontractor actually
Page.
Lordship. And my learned friend submitted that there is no privity of contract, which is not correct. Lordship, the agreement starts from page 21, annexure 4.
Which is that part?
Yes. Lordship, may please to come to page 39. Page 39, Lordship. This is the part of the annexure. Obligation heading is page 38, Lordship. Obligation of the contractor. Then last clause number, Lordship, 3.2, page 39. Obligation relating to the subcontractor and any other agreement. 3.2.1. The contractor shall not subcontract any works in more than 70% of the total length of the project highway. It means, Lordship, up to 70% of the total length, subcontractor can be awarded and shall carry out works directly under its own supervision and through its own personnel at least 30% of the total length of the project highway, provided, however, that in respect of the works carried out directly by the contractor, it may enter into contract for the supply and installation of the materials, plants, equipment, furniture, safety device, labor, the case may be works for the aforesaid length of 30% is no more than 5% sections of the project highway. The party further agree that all obligations and liability under this agreement for the entire project highway shall at all times remain with the contractor. The parties also agree that obligation of the contractor to carry out works directly in at least 30% of the total length of the project highway will be discharged solely by the lead member. Then Lordship may come to next clause, clause 3.2.2. In the event any subcontract for works or aggregate of such contracts with any subcontractor exceeds 5% of the contract price, the contractor shall communicate the same and particulars, including the relevant experience of the subcontractor, to the authority prior to entering into any such subcontract. The authority shall examine the particulars of the subcontractor from the national security and public interest perspective and may require the contractor no later than 15 days time from the date of receiving the communication for the not to proceed with the subcontract, and the contractor shall comply herewith. Clause, next clause. In the event any subcontract referred to clause 3.2 relates to subcontractor or who has over the preceding 3 years not undertaken at least any work of the similar nature with a contract value exceeding 40% of the value of the subcontract to be awarded hereunder and receive payments in respect of for an amount equal to at least 40% of the authority may no later than 15 days from date of receiving the communication from the require the contractor not to proceed with such subcontract and the contractor shall comply herewith. Next, 3.2, 2.4. It is expressly agreed that the contractors at all times be responsible and liable for all its obligation under this agreement, notwithstanding anything contained in the agreement with subcontractor or any other agreement that may be entered into by the contractor, and no default or any such agreement shall exclude the contractor from its obligation and liability. Lordship. Their lordship may come to the bottom. Clause number 3.4.1. The contractor shall ensure that the personnel engaged by it by the subcontractor in the performance of the obligation under this agreement are at all times respectfully appropriately qualified, skilled, and experienced in their function in conformity with the good industry practice. Then your lordship may come to 3.4.3. The contractor shall, on receiving such a direction from the authority engineer means lordship NHIDC, order for the removal of such person or person with immediate effect, it shall be the duty of the contractor to ensure that such persons are evicted. This is not so relevant. Next page, lordship. Lordship may come to page 43. Page 43, lordship, last para, third clause F. Upon written request from the contractor and subject to the provisions of the clause 3.3, provide reasonable assistance to the contractor and any expected personnel of the contractor or the subcontractor to obtain application visa work permit for the purpose of discharge by the contractor or its subcontractor or their obligation under this agreement and the agreement with the subcontractor. Then lordship may come to lordship may please to come to page 125. 125. Clause number lordship.
Yes.
Clause number Page number 125, Lordship, clause number 24.1. Heading is restriction on assignment and charges. This agreement shall not be assigned by the contractor to any person save and except with the prior consent in writing of the authority, which consent the authority shall be entitled to decline without assigning any gift. So there was a assignment of the contract, Lordship, from to the present petitioner, Lordship, and which was duly approved by the NHIDCL, that your Lordship will get at page. Lordship, I am pleased to come to page 151. 150. Annexure 6, Lordship, this is dated 17/10/2016, written by the NHIDCL authority, Lordship, DM planning to the DM technical, Lordship, regarding the capability of the present petitioner, Lordship. Under subject referred letter, MS Portion Carbium SA, that Swedish company, has submitted a proposal for giving additional 4 laning works, 2.3 kilometer length further for his subcontractor Green Deca, that is the present petitioner, Lordship, who was earlier given a work in 2.88 kilometer length under subject package. The proposal has been checked in detail by AE, that is authorized engineer, and the detailed recommendation accordingly have been submitted by the resident engineer MS Fisherman Prabhu, Lordship, a chartered accountant, renowned chartered accountant firm, Lordship, headed by the previous railway minister, Mr. Prabhu. Right there, letter number so and so, enclosed with the letter. The above additional work has been proposed to Mr. Girin Deka due to completion of additional work worth of rupees 10.7 crores by a firm in PWD due to his, which has been eligible now for taking up additional work worth of rupees 27 crores, since per kilometer cost of the work under the package is 11.57 crore. Therefore, additional 2.33 kilometer work can be awarded to this firm on the following reasons. So these are regarding we are having next page, Lordship. Subcontractor, page 152. Subcontractor, Mrs. Green Deca has also purchased WM plant, batch, mix plant, so machinery. Green Deca had established his came along with facilities of quality control lab. Green Deca has brought desired number of vehicles, equipments plant at site and carrying out CNG work and earth work, and he has already started the work activities at the site under tennis number 4, so which already been awarded to him through subcontract in view of the above mentioned development. Under this package, in last 2 months, Mr. Girin Deka has proved that they are capable of executing the work as subcontractor to them by MS Portion Corbium SA. Therefore, above case is recommended for finalization in the interest of the work. So on this, Lordship, the next annexure, my subcontract was approved. That is annexure 7, page 153 by the NHIDCL. Para 2 deals with the government's Lordship, the subcontract of the petitioner was approved. And Lordship, not only that, Lordship, the clause number Roman 3, Lordship, speaks regarding execution of a tripartite agreement between the NHIDCL petitioner and the main contractor, Lordship. And that agreement was also executed. Then, Lordship,
Tripartite is between whom, amongst whom?
Tripartite was a lordship with the NHIDCL, the main contractor, and Green Deck and some other person. And interesting thing is this lordship in executing the work, the person, other subcontractors whose contract was not approved by the NHIDCL, they have been paid full paid amount. And they have admitted it. Yes, they had paid. The contract which the subcontractor who other subcontractor who executed the work, lordship, without having the approval from the NHICP, they have got the payment. And why the petitioner has been discriminated, I fail to understand.
So what works other contractors will do? When the entire works were given,
Regarding lordship, installation of utility services, lordship, removal of the old post, electric post, telephone post. Regarding that, without approval, the NHIDCL paid this up. And this is it has been admitted by the NHIDCL in their affidavit. Now your lordship may come to and for this interesting thing is this lordship, may be pleased to come to page 151. For paying the amount to me, lordship, they have deducted the TDS from my bill and they had deposited to the income tax department, lordship, but the amount was not paid to me. Page 158.
158.
150. Lordship may please to come to page 159, which shows the TDS deduction, lordship, from the bill of the main contractor, lordship. But the said amount was neither paid to the main contractor, not to me. In the lordship 159, amount total TDS deposited, they have shown 1 crore 24 lakhs. 1 crore 24 lakhs 960.80. The NHIDCL had deposited the TDS from deducting the bills, but this amount was never paid either to the main contractor or to me, Lord. And
Where in page 150, can you again explain?
Page, lordship, this is
The TDS forms.
This is the income tax form, lordship, page 158, form number 26. Yes, lordship. Return which was filed by the NHIDCL before the income tax authority. And at next page, lordship, 159. Your lordship will find name of the main contractor on the left side, portion Carbium Construction TASA, and a lordship, the total amount, the right side, lordship, total TDS deposited 1 crore 24 lakhs or 6,001. They have deposited by deducting from the work which was done. I had executed, Lord. The TDS paid, lordship, when the bill amount is paid, then only it is deposited in the income tax department, lordship. But it is admitted fact that this bill amount was never paid either to the main contractor or to me. Then, lordship,
Your contention is that since TDS has been deposited,
yes,
it could not have been deposited unless there is a liability to pay you.
that is. Lordship may be pleased to come to page 356, by which the authorized engineer, lordship, advised the top authority of the NI to clear the dues of Green Decker, lordship. Page 356. And under the NHIDCL Act, lordship, the documents, only the bills are, advice are given, whenever the advice is given by the authority engineer, authority is bound to pay. They cannot escape. That is the provision in the contract also. Page 356 lots.
Yes. 21.8. 21.8, isn't it?
Yes. They start lordship from page lordship 356 and it's 13. This is the letter written by the authorized engineer lordship. Authorized engineer of the Fishman Prabhu lordship, where your lordship will find that page 356 lordship, page 357 in the middle lordship, MS Corsair Carbon Construction essay has neither confirmed nor the lordship got it.
Yes.
Has neither confirmed nor complied as requested above under serial number so and so under the provisions of clause 23(4) of the Contract Act. Authority engineer comment on these issues is under Messrs. Corson Carbium Construction had no plans and materials at their own site. The work was executed by their subcontractor. So no any plant and materials have been handed over to the authority. Then lordship may come to each clause at the bottom. Wilson Corson Carbium Construction SA personnel left the site of the site in first week of May 2017, and the site office was also closed in May 17. After that, no person from Mercer Corson Carbium Construction SA has seen at site. Authority engineer presumes that the site has been vacated by Messrs. Corson Carbium Construction SA. The road maintenance estimate was submitted before termination of the contract and amount of rupees so and so for carrying out the maintenance work and at the risk and cost of the EPC contractor. Your lordship may escape. Then your lordship may come to middle portion of this page 358. Calculation of damages work out under clause 10.3.2 of the contract agreement due to non-achievement of the milestone by the contractor Corson Carbium Construction SA is under. So lordship, after this is regarding calculation of liquid damages, all this. After deduction of everything, lordship, your lordship may come to
The chart.
yes, this amount is payable, lordship. Page 359, 359, the last page. The value of the payable amount after adjustment of sum of rupees, they have adjusted the liquid damages from rupees itna crores 100 itna. The net value of the amount adjustment is itna of rupees 10. Only that. So this amount is payable, lordship. Net payable amount after deductions of all the liquidated damages 10 crores 86 lakh 65,241 to remain to the contractor loss. This is their document loss. Now your lordship may come to page 380, where is clear cut admission by the NHIDC.
But this amount at page 389.
Yes.
The adjusted amount 10 crores 86 lakhs.
Yeah.
Will it cover your case? Is it for the work done by you?
No.
Or is it also work part of the demo pack?
This includes, lordship, this here, it is
See, there are two packages, Jorhat
yes,
to
yes,
Jhaji
lordship.
and Jhaji to demo.
Yes,
You are interested from Jorhat to Jhaji.
yes,
This amount at page 389,
yes.
does it pertain to your sector?
Both,
Jorhat to-
it includes both lots. It includes both. Thereafter also, the termination amount is payable is 10 lakhs 86, and as per the contract, it is to be paid within 30 days from the date of termination. Because let's see, what's are very clear, net value of the payable amount after adjustment comes to rupees so and so. There is no dispute. That is their it is the document of the NHSC. Yes, sir. And how can they can deduct of the contract which never assigned to me, that is Jhanji to demo lordship. That is also illegality. I am not responsible for any deeds of the main contractor from lordship Jhanji to demo construction lordship. And lordship may come to page 318, annexure 14. Here also lordship, after termination, the remaining contract was given to Denong Dunkerley Company Limited by the NHIDCL. Here also payable amount to me is admitted.
Please.
Please, lordship, please Sekji.
$360.
Yes, lordship. This is the letter written by the lordship, team leader of the NHIDCL lordship, the topmost official. In consequence to the termination of the contract, Jorhat Jhaji section NH happened due to gross default on the part of the previous EPC contractor, Caution Carbium contractor SA. Authority engineer determined the value of the unpaid work completed under progress as per the provisions of the contract agreement clause number so and so. The gross value of the unpaid work determined by the authority engineer is rupees so and so. Out of which work executed by subcontractor subcontractor MS Green Deca is rupees 11 crores 6,85,770 and is rupees 1 crore 90 lakhs so and so 900 and 100. The details, measurement sheet and valuation of the unpaid work is enclosed here. So regarding my amount, lordship, there is no dispute. Repeatedly in other document annexures also, which are the documents of the NSID, they have admitted. And not only that, in the affidavit in opposition, lordship, filed by the NHIDCL, they have clearly admitted. So lordship, me please to take up the affidavit in opposition filed by the NHIDCL lordship, para 40.
Paragraph
Para 14.
1-4.
Yes. You got it? Para 14.
40, there is only one line. Affidavit is dated what?
Affidavit
Who's
is
the deponent? Ajit Pal.
Deponent.
Ajit Pal.
I have misplaced my copy of affidavit.
It is Ajit Pal Singh Brar.
Position. Every প্রথম যদি না NHID epidemic নহয় পাতল আছে
Paragraph 14, there is only one line. That with regard to the statements made in paragraph 31, petitioner of the deponent begs to offer no comment.
Epidemic notation. No, I wrongly quoted the paragraph. No. Oh, yes, I got it. This is the affidavit in opposition lordship dated 25/2/19, filed by one lordship, yes, Ajit Singh Barar.
Yes.
Here lordship in
Ajit
para
Pal.
11.
Yes, para 11.
11. Para 11. 8. That with regard to the statements made in paragraph 27 and 20 of the writ petition, the answering deponent begs to state that in consequence to the termination of the contract for lending from Jorhat to Jhaji section NH 37 due to gross default on the part of the previous EPC contractor, Messrs. Corson Carbium Construction SA, authority engineer determine the valuation of the unpaid work as per the provisions of clause 23.5 article 23 of the Contract Act. The gross valuation of the unpaid EPC work completed, uncompleted, determined by the authority engineer on rupees so and so, and subcontractor Green Deca scope of work is rupees 11 crore 6,85,770, and under a scope of other subcontractor is 1 crore 19,49,9 lots. So, Your Honor, here also in their affidavit, they have clearly admitted lordship that the petitioner has executed the work, and even lordship, this 1 crore 49,560 was paid to the other subcontractor who were never approved by the NHI. This is also admitted position. Now, lordship, will you please to come to the lordship, may you please to come to lordship, may I be pleased to come take up the affidavit in reply given by the respondent number 3 and 4, that is NHIDC, where they have clearly categorically stated that work of the main contractor is nil.
Who's the deponent? Z. Samson.
Lordship, affidavit in reply.
Who's the deponent? Z. Samson.
Deponent is lordship.
Z. Samson Vijay
Z.
Kumar.
Samson, yes. Lordship may come to para 9, Roman 7.
Which page?
Lordship, para 9, Romans.
Para 9.
Sorry. Is Lordship, para 4, page Lordship, this is annexure, page 9. Page 9 Lordship, para. Para 4, utility shifting. It is reported by AE that the gross value of the work paid prior to termination was rupees. So this bill is already been paid. This is portion for VM prior to termination. As this cannot be recovered as by the headquarters. Apart from that, as certified by AE, as for work done, there is outstanding work of rupees so of the work done has been paid. However, the contractor has not submitted any proof of payment to the subcontractor, nor the subcontractor has given any undertaking that they have received this. Therefore, the payment of rupees so cannot be reimbursed to Messrs. Courts and Carbion. We mentioned that the subcontractor are making representation to MD and HID for payment of their dues. In this regard, a meeting was held at headquarters with subcontractor, with director technical and director of Mr. So-and-so, wherein it was decided that the contractor would raise the bill with Mr. GDCL and his payment shall be made through the GDCL. Accordingly, a termination payment of rupees so-and-so payable to the contractor portion Carbium and rupees subcontractor of electricity to TDCL. This is not relating to me, but this is other utility contract. Then Lordship. May come to page 30. After calculation of all the liquidated damages, Lordship, including the amount of the petitioner and other subcontractors. Last line, Lordship, page 30. Accordingly, a termination payment of rupees. Termination payment of rupees 15,805,84227 recoverable from the EPC contractor portion is recommended for the further consideration. So Lordship, this amount was recoverable only from the main contractor, not from the me. Lordship. And then Lordship. Please to come to page 15. Page 15, Lordship, of the para 10, Lordship. Para 9 and 10. Para 10 is most. Where is affidavit hol apna affidavit reply apna logo dated 19/1 para 10 Lordship. Whereas the contractor initially via letter number so and so submitted a proposal to the authority for subcontracting a length of 10 kilometers so and so to Deka, but the contractor letter contractor by letter number so and so modified the proposal for subcontractor containing 4.3 kilometer this and that, and subsequently Green Deca was found eligible for subcontracting a length of 2.88 kilometer, which was approved by the authority. This shows Lordship. Then Lordship para 11. Whereas the contractor by letter dated so and so submitted a proposal to the authority for subcontracting a length of so and so to regarding this is the other contractor, Lordship. Then Lordship may come to page 18, Lord. Page 18. This is the letter by the NHIDCL Lordship, the portion Carbium construction law. Where is para 9 Lordship? Para 9.
This is 28.4.
Lordship.
28.4.
Yes, sir. 28/4/17, para 9 Lordship, which will prove that the main contractor did not work anything, did not do anything. Lordship, page 20, para Roman 7. At the bottom, whereas the contractor failed to carry out the work on minimum of 30% of the estate as per clause number so of the contract agreement, the work taken up by the contract themselves as on date is nil, and the mobilization status of the plant and machinery is also nil. The project has
Which we're reading for? Page 20.
page 20 last,
Okay.
Roman 7.
9.7.
Yes, sir. Yes. Whereas the contractor failed to carry out the work on a minimum of 30% of the estate as per clause number so of the contract agreement, the work taken up by the contractor themselves as on date is nil, and the mobilization status of the plant and machinery is also nil. The project hereby jeopardized and put in peril for the construction as a result of non-compliance of the terms and conditions of the contract agreement. So, Lordship, there is no doubt that the entire work was executed by me, amounting to more than rupees 11 crore. And Lordship, I had availed the loan from the small banking Lordship, as well as the MSME Lordship, you know, more than 10 crores. And now my account become NPA. I am surfacing notice has been served, Lordship, and at any time I can use my all those documents are here on record, Lordship, due to non-payment of the bill amount. So it is, Lordship, beyond, there is no doubt that entire whatever work of rupees 11 crore plus was done by the present petitioner. Nothing was done by the main contractor, and the
Mr. Saikya at 359. Mr. Saikya. That chart.
net amount payment, net amount payment, termination amount.
See there, your projection does not appear to be consistent with this. That you say that the liability which the Swedish company has is much more than the amount the Swedish company is entitled from you. See here, even after the recovery, there is an amount of rupees 1086, 65 to 47.
This is respect to this the contract which the subcontractor is involved.
No, understood. But if you see the chart has been prepared keeping in view the Swedish company, not the petitioner. They have treated you have treated the work to be done by the contractor. You are not too much bothered whether it's done by Mr. Roy or by the Swedish company. Now this, after admitting this and having adjusted the recoverables, then also 10 crores are remaining to be paid. Why don't you make the payment?
The Johar to Judge section.
Johar to Judge his boss.
I am confined to Johar to.
So, madam, this amount is payable by the NHIDCL to contract. This 10 lakhs are not. Then, madam, the recovery amount.
Not 10 lakhs, 10 crores.
10 crores, it is lakhs.
Hmm.
The other, my lord, from Haji to this Demo. There, the NHIDCL is to recover only about 12 crores and all.
He cannot be made there. That liability
So this
cannot be,
amount has been,
that liability cannot be settled with him. There are two different works.
this is basically the whole, the responsibility has been.
There are two different components of work.
Lordship, there are two separate agreements. The agreement is also not same.
My lord, who executes the work, my lord, whether contractor or the subcontractor, is not the lookout of the, my lord, NHID, but I have from that.
Now,
All
suppose-
the responsibility. and liabilities.
Suppose A part where we are concerned, Jorhat Jaji A, you give it to a Swedish company. B part, Jaji to Demo, you give to some other company. In this case, what would have happened?
It would have been different, perhaps would have been different.
Now here, if that could have been different, only because the Swedish company is also involved in another work for where you want to make some recovery.
So certain
Can you make
clauses-
him,
Certain clauses are there where from these can be recovered.
we'll come back, but yeah, Chaudhary, which matter is this? 30? Hearing matter. Who's on the other side?
Chaudhary is likely tied up with some other code. So may I pay to come better on it? That's not has.
Let me Thursday.
Thursday, which matter? Person
31.
Lucky radio, sir.
31.
30 and 31.
30 and 31.
On a request made on behalf of the KN Chaudhary and the Senior Counsel for the respondents, na?
Respondent number 8.
Provide the private respondent. Who's for the department? Is it AFDC or Mr. Sharma? Oh, cooperation department, not fishery.
Fishery matter.
Yes, sir.
Why cooperation?
Cooperation department has been very party because of the fact that my lord, certain provisions of the act have not been.
On Thursday means the date
27.
27.
of license.
Interim order is there over? No.
No interim order, my
Term is not over.
term will be over in September.
We'll do after September then. Okay, that's it.
All right.
Yes.
Yes. Lordship, I'm pleased to come to page 134. Because my learned friend had submitted that there is no privity of contract between the petitioner and the NHS, this is not correct. Lordship, may come to page 134. Clause number, page 134, Lordship. Clause number at the bottom, left side, clause number 27.11. Third parties. The agreement intended solely for the benefit of the party and their respective successor and permitted assigns. And nothing this agreement shall be construed to create any duty to a standard of care with reference to or any liability to any person not a party to the agreement. My humble submission in this lordship, this clause 27.11 clearly states that when my subcontract was approved by the authorities lordship, I was a permitted assign. There was a assignment lordship and successor to the original contractor, your honor, and as well as the assigned. So I was one of the assigned. So the submission made by my learned friend, there is no privity of contract, is not tenable. Then lordship, next page 135. This agreement, first top line, this agreement shall be binding upon and inure to the benefit of the parties and their respective successors and permitted assign. So this plea, my learned friend, there is no privity of contract, is not tenable. Then lordship, lordship, may please to come to clause number 23.63.
Page,
Page lordship.
termination payment,
Yes, Lord.
122.
Yes. Lordship, when the contract of the original contractor was terminated, Lordship, the payment is to be made within 30 days. Lordship. The remaining amount payable to the contractor. Lord. And if it is not paid, Lordship, interest at the rate of 2% on the basic rate of the blending rate of the bank will be realized from the authorities, Lordship. That is the provision. 23. 23.6.3. Yes, 23. Termination payment shall become due and payable to the contractor within 30 days of a demand being made by the contractor to the authority with the necessary particulars. In the event of any delay, the authority shall pay interest at the base rate plus 2% calculated it with quarterly rest on the amount of the termination payment remaining unpaid, provided that such delay shall not exceed 90 days. For the avoidance of the doubt, it is expressly agreed that termination payment shall constitute full discharge by the authority of its payment obligation in respect thereof. Now, Lordship.
Now, what is the meaning of termination payment?
Termination?
23.6.
Yes. 20.
No, in page 122 itself.
The termination shall become due and payable to the contractor within 30 days.
No, the first clause, 23.6, termination payment. 122, the top first.
A termination payment, yes.
Then
Upon
23.
termination on account of contractor default under clause 23.1, the authority shall, in case and appropriate the performance security, retention money, so the bank guarantees all these.
Now, what is it? C? What is C?
C is not the party to the.
23.6.1C, pay to the contractor.
Pay to the contractor by way of termination payment an amount equivalent to valuation of the unpaid works after adjusting any other sums payable or recoverable as the case may in accordance with the provisions of this agreement. So they cannot take the plea lordship that from Jhansi to Demo lordship, they will adjust lordship.
So even if there is a termination on account of the contractor's default,
Yes,
then also they are under an obligation to pay termination payment, that is the amount equivalent to the valuation of unpaid works.
unpaid.
Unpaid works.
Yes, which I've already produced before lordship. It is
Works
all-
for which payment has not been done,
Done.
that payment has to be made in spite, even in a situation where the termination has to be done on account of the contractor's default.
Contractor default. Here in the present case lordship, even there was no default on the part of the original contractor as well as the subcontractor. As because lordship, when the first running bill was submitted by the present petitioner on behalf of original contractor, they did not pay the amount within 30 days. Whereas the contract clauses stipulate that whenever a running bill is submitted, it must be clear within 10 days regarding running bill lordship. And if it is not paid, again interest at the base rate of the lending of the banks plus 2% with quarterly rest, the authority will be bound to pay loan. So that was my argument on the part of the contract lordship best. And lordship, then I would like to place. Now, before that, lordship, I would like to place the provisions of the MSME Act. According to which even your lordship, if there is no contract, if any service is rendered by any party lordship, they are bound to pay the amount lordship. That I have annexed. First of all, your lordship, may please to come to page 16.
Page
16, 1/6. Page 16 shows lordship that the Director of Industries and Commerce Center, Udalguri lordship, has granted this certificate to the petitioner that is this his firm is registered under the MSME Act. Then lordship,
where do you get MSME?
page 16 lordship,
Yes.
Office of the General Manager,
Hmm.
District Industry and Commerce Center, Udalguri, Certificate of Issuance, EM. Green Deca, a steel fabrication and field memorandum of a manufacturing enterprise, village so and so, Udalguri so and so items, active has comments from this and that. The date of the issue 1712, category enterprise, micro entrepreneurship memorandum, this and this, then the steel gate, grill, steel fabrication, roof truss, welding and cutting. So this shows that under the MSME, this firm is registered. Then the second certificate is lordship of the
No, where do you get MSME here?
lordship. Micro status is given.
Category of industry, enterprise, micro.
Yeah, micro. So this is a micro small enterprise as per the provisions of the. Next is lordship is 20, annexure 3. This was issued by the Udyog Aadhar lordship. Government of India law.
Page
Page 20 law. So this certificate was issued by the government of India, Lordship. And here also this shows that it is a micro, small industry. Then Lordship, it will be, then contract agreement begins. So there is no doubt, and in the affidavit of opposition also, the respondents had not denied this. Now your Lordship may be pleased to take up the my MSME Act, Lordship 2006.
MSME. Yes, please.
Lordship may come to the first page, definition of the buyer. A small d at the bottom, Lordship. You got it? Of section 2D, a small d. Definition of buyer means whoever buys any goods or receives any services from a supplier for consideration. So I have rendered the service by constructing the energy. Then your Lordship may be pleased to come to section 15. Liability of buyer to make payment. Heading is Lordship, liability of buyer to make payment.
Section 15.
15. Definition is the Lordship, where any supplier supplies any goods or renders any services to any buyer, the buyer shall make payment. Therefore, on or before the date agreed upon between him and the supplier in writing, or where there is no agreement in this behalf before the appointed day, provided that in case the period agreed upon between the supplier and the buyer in writing shall exceed 45 days from the day of acceptance or the date of deemed acceptance. Next section 60. Date from which and rate which interest is payable. Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time being in force, be liable to pay compound interest with monthly rest to the supplier on that amount from the appointed day, as the case may be, from the date immediately following the agreed upon at 3 times of the banking rate notified by the RBI. So, Lordship, if any buyer fails to pay the amount, Lordship, then it is bound to pay above the bank rate or as fixed by the RBI 3 times with monthly rest to be compounded with the monthly rest. Recovery of amount from due. This is regarding through the Industrial Facilitation Council. And then, so Lordship, here the scheme of the MSME Act is this, Lordship, even if there is no agreement between the parties, Lord, and the appointed day has been defined under section Lordship, what will be the appointed day that has been defined under sections appointed day, Lordship, section 2 within bracket B, appointed day means the day following immediately after expiry of the period of 15 days from the date of acceptance or the day of deemed acceptance of any goods or any services by a buyer from a supplier. Lordship. So, within 15 days, Lordship, if no objection is raised by the buyer, Lordship, it will be deemed that the appointed day, 15 days period has expired and they will be liable to pay the amount to the. So, Lordship. Now, your Lordship may be pleased to peruse. I have taken a bank loan already. I have submitted before your Lordship.
Surface notices has been served upon you. You have said that surface notice has been served upon
I have
you.
also stated in the benefit annexing the all the loan documents. And now that account become NP. Lordship, earlier I had given a set of judgments, apex court as well as on mainly on section 70 of the contract. এনেকুৱা হ'ব বা it is mostly all the judgments of the apex court or our honorable high court and different courts are on section 70 of the contract act, where all the judgments held that even if there is no agreement, there is no oral or verbal contract, but the work has been completed and the other side is getting the benefit. In that event, the person who is benefited is bound to take the amount. In all the judgments, our high court judgments are also there. There are, if your Lordship allow me, I may read.
Which one?
First of all is the Mulchand Lordship, 1968 ARSC 1248. I will just place relevant.
You need not read the entire judgment, you can.
Page 8, Lordship, please to come. Of this.
Regarding fulfillment of three conditions of section 70.
Yes. It starts, Lordship. Second para, person from whom something is done or whom something is delivered must enjoy the benefit thereof. If these conditions are satisfied, section 70 imposes the latter person the liability to make compensation to the former in respect or to restore the things done or delivered. The important point is notice, import to notice is that in case falling under section 70, the person doing something for another, delivering something to the delivering something to another cannot sue for the specific performance of contract or ask for damages for the breach of the contract for the simple reason that there is no contract between him and the other person for whom he does something, to whom he delivers something. So where a claim for compensation is made by one person against the another person under section 70, it is not on the basis of any subsisting contract between the parties, but a different kind of obligation. The juristic basis of the obligation is, such a case is not founded upon any contract or tort, but upon a third category of the law, namely quasi-contract or restitution. Restitution and any civilized system of law is bound but to provide remedies for cases of that that has been called unjust enrichment or unjust benefit, that is to prevent a man from retaining the money or some benefit derived from another which is against conscience, that he should keep such remedies in English generally different from remedies in the contract or in tort, and are now recognized if called within the third category of the common law, which has been called quasi-contract or restitution. So this is almost all the judgments are based on the same principle and followed the Mutation case, Lordship. Our Guwahati High Court judgment is at page 10, Lordship, and page 10 of this bunch. Then second, our own High Court judgment is page 13, Lordship, NHPC Limited and others versus Oriental Engineer. Same law point has been laid down. Then Lordship, another judgment is page Lordship 28, page 28 of our own High Court. Cantonment Board Appellant versus Savitra Devi Joshi. Then Lordship page, another Supreme Court Apex Court decision is at page 35, Lordship, Relevant Para 4, your Lordship. The citation is 1966, Lordship. Supreme Court decision. Para 4, page 37, continuous page 37.
Ratanlal.
Yes. Several contracts thereafter came before this court and were several contracts therefore came before the court and were considered in the state of West Bengal versus BK Mandal and Sons and the New Marine Company Bengal versus so and so. So these cases laid down if the contract fails. If the contract fails, payment may be ordered quantum merit on the basis of Section 17 of the Indian Contract Act for any benefit received as a result of the contract. In the two latter case, it is emphasized once again the provisions of Section 175(3) of the Government of India Act were mandatory and not direct. So, Lordship, my placing the judgment, because just to counter the submission, whatever my learned friend has made, that there was no privity of contract. Suppose, assuming for the moment the Lordship, there is no contract, there is no privity of contract, then also I am entitled to get the amount under Section 70 of the contract. I have constructed the road, the public is using it, they are collecting the road taxes, toll taxes, every type of taxes they are collecting, and they are getting the benefit. And only I have been deprived. So all these judgments are based on that principle, Lordship. And as well also under the provisions of the MSME Act, I am entitled to get the amount along with the interest at the Lordship 3 times of the pay. Lordship. And one thing I would like to submit with what is assignment, Lordship, that is clearly stated in the black spot. Very low. The assignment that leaves the assigner no interest in the assigned property or right, effective assignment, and assignment that terminates assign a interest in the property and transfer it, assigning. Next Lord. And the bunch I have submitted, Lordship, there are judgments of. So once the subcontract was approved by the NHID Lordship, I step into the shoes of the original. Lordship, me pleased to note one vital fact. Lordship, when the Jorhat Jhansi contract was terminated of the respondent number 5, Lordship. Thereafter, 1.5 months thereafter, from the date of termination of the Jorhat to Jhansi, the Jhansi demo contract was terminated after 1.5 months. 1.5 months. And liquidated damages have been imposed or I have been settled with for the recovery of the losses, if any, of the contract, Jhansi to demo.
How much is your amount you're claiming now?
My amount is, Lordship, because I will not claim whatever was unpaid amount in the termination contract. That I will be said, along with interest for the MSC Act or the base rate of the bank. I leave it to your Lord. I have suffered a lot without no. One thing, your Lordship, yes, sorry, one thing I would like to say. Lordship, see, in every meeting, the present petitioner was called to participate held by among the officials of the NHIDC.
Where have you seated?
Lordship. Yes. Yes. In my additional affidavit, Lordship, dated C-12/20. Page 39. Page 30. Additional affidavit filed by the petition on 3/12/20. Page 30. Got it? Connection.
Page,
Page 39.
minutes.
Yes, minutes of the third meeting conference held at PO NHIDCL Tezpur on 20th September 2016. Work conference on various packages lagging behind in Assam was conveyed by the GM planning Tezpur in following officials were present. All the top ranking official and at the bottom so my name lordship, serial number N, Green Deca, subcontractor. And if there was no privity of contract, why was called in such a high meetings of the officials of the NHIDCL? And here also there is admission lots. In this letter, it's minutes accounts. Let's may come to page 40. Page 40. Clause number 33, lots of B, a small b, 33, a small b. Mobilization of research and manpower not done till date, except subcontractor research of Green Deca. Everything was done by me. Then lordship may come to yes, lordship, next page 41. Page 41, clause number 37, lordship. AE means authorized engineer, told that subcontractor Green Deca had established base camp on channel number so and so where batching plant established and WMM plant has arrived. WMM plant likely to be installed by 30th September 16. AE to submit confirmation in regard by up to 1st October 16. He also told that crusher of 200 TPH has been installed by the subcontractor Green Deca at Howlo Watting near Arnagut for Janji. Production has been started. Approval itna CM stones has also been obtained by the contractor from concerned department. AE stated that the following resources have been brought at site by the subcontractor Green Deca. So all lordship, the masonry names are mentioned here, which cost not a single machinery is less than of 50 lakhs, 60 lakhs, even crores. Then lordship, page 41, para 38. Is told that at present Green Deca has been given 2.8 kilometer of a stretch and proposal for additional 2.2 kilometer has been obtained from portion. After 5 kilometers to be executed by Green Deca, in addition to this, still 30% of the Jorhat Jhansi package remains under portion Carbium, which is not handed over to Green Deca, nor they have any plan for doing by themselves. GM planning told that AE that headquarter NHIDCL will be requested to take up this matter with portion Carbium headquarter level. As per opinion of GM planning, as Mrs. Green Deca has sufficient resources and capable also to take up their 30% works if handed over to Green Deca by the company. GM planning told that no further time will be given to portion Carbium. They should submit their plan of complete stretch by 30th September 16 to AEGM planning told DGMP regarding removal of the resources of subcontractor. This is Sahabuddin, other contractor. DGMP told that notice has already been served and the confirmation on the same will be in course of time. So lordship, the plea, the next lordship, page 43.
page 43. Clause number lordship 47. DM planning told contractor that the next meeting will be held on 5th of October 16 at Tezpur office for packages of the course and carbium, and all above issues will be reviewed. DM planning mentioned that in spite of this clear direction, no senior officials had attended the meeting, including project manager of Pure Heart Dhasi package. Therefore, no further time will be given after 5/10/16 to clarify all these pending issues. DMP asked AE to keep termination notice ready by 5th October 16. If contractor do not give clear plan of the various issues, this notice will be served on 6 October 16 as branch office recommendation for termination of the contract. For learning of the Your Lordship from Jhansi to, this is regarding the more Lordship, in which I am not a party. So Lordship. And this copy of this letter was also endorsed to the petitioner Lordship. This minutes of the page 46 at the bottom. Your Lordship will find copy was forwarded minute of the minutes at serial number 30, Green Deca, subcontractor. Submission.
That we have pointed out. Okay. How long will you take? 15 minutes.
So first work done by him. He was a subcontractor, was not a assignee. Assignee has a different meaning as he has read method. So which casual. So the assignment is altogether a different method. When the rights and liabilities has been transferred, he is denuded of the rights and liabilities after it is being assigned. So here it is not the case. The subcontractor on behalf of the contractor, he executes all the rights and liabilities of the contractor remain intact. Now, my lord, you will find page 153.
What is the difference between a successor and an assignee?
Successor, the person who succeeds. Be a legal representative or
Does one have a role in a matter going to the successor vis-a-vis his role in appointing an assignee? If it goes to a successor, it goes by default.
goes by the
There is no overt act. But to give it to an assignee,
sign.
there has to be an overt act that I assigned the work to you. But if I die, it might go to my successor. It is on default.
On the, that's right.
Here, if to go to an assignee, there has to be some overt act
Yes,
by the principal contractor.
yes.
Now, he says that there is a privity of contract between him and the Swedish company, which is also a part of the main contract between you and the Swedish company, which recognizes a situation where the principal contractor can appoint a subcontractor.
My lord, the so far as my lord, subcontractor is concerned, my lord, kind of my lord, the qualification the subcontractor may have, that has been given there. My lord. So if that is that fulfills, my lord, he can go for a subcontract, but by appointing the subcontract, he is not relieved from the responsibility or the liabilities from the contract,
Who is not relieved?
the contractor.
To this company.
Yes. It is between the contract is subcontract between him and the Swedish company. We have nothing to do with
That-
only qualification we see, since you want to appoint a subcontract, we have seen this qualification, okay, go ahead with that. But then all the responsibility and liabilities, all the payments, everything will be with the as per the contract. That is the basic and that you'll find even in the approval of subcontractor letter by which we have approved it. Is at page 115. May I read the matter? The whole from this document itself, page 153. Page 153.
Yes, please.
Paragraph 2 onwards. Based on your proposal submitted for giving subcontract to Green Decker for additional length of 2.32 kilometers, the proposal has been approved in principle by our headquarter NHIDCL subject to following conditions. As the subcontractor is eligible for execution of additional work for rupees 26.94 only, which would be equivalent to cost of 2.30 additional length of the project based on average cost of per kilometer. The contractor has the damages of this subcontracting by letter number for a length of 2.33 kilometers. This subcontractor will be governed by the contract agreement signed between MOD and the contractor, Messrs. Corson Program Construction SA on 19/11/2014, and tripartite agreement signed between MOD contractor, Messrs. Corson Program Construction SA and NHIDCL on 5/5/2015. Tripartite agreement, initially the contract was executed between the MOD of Road Transport and the Corson Program. Subsequently, the project was handed over to us for its execution. After this tripartite agreement was made, that is between MOD, then the contractor and the NHIDC.
Admitted.
That is the response. Next, the responsibility to complete the project as per Schedule J and all other clauses of agreement dated 19/11/2014 and tripartite agreement 5/5/2000 contract fully lies with contractor. Messrs. Corson Program Contractor SA. Consent to subcontracting of a part of the project length of the subcontractor, Messrs. Green Decker, shall not absolve the contractor of any responsibility to execute and complete the project as per the contract agreement signed on 19/11/2014, tripartite agreement signed on 5/5/2015. The act of subcontracting shall not absolve the contractor of missing the first milestone mentioned in Schedule J of the contract agreement and penalties of missing it. The contractor shall also be responsible for achieving all milestones as per Schedule J in future. In case of failure of subcontractor either to execute work with the time or of required quality, all the actions as mentioned in the contract agreement shall be initiated against the contractor. All the liabilities are with the contractor. It cannot be said to be an assignment. The contractor shall supervise the work of the subcontractor regularly. The contractor shall also deploy his own skilled manpower to supervise the work carried out by subcontractor to ensure quality as contract provisions. The RFI shall be raised by the contractor, which shall contain the name of their own supervisor engineer who would be responsible for the execution of that particular work as per the requisite standard and specification of the contract agreement. Proper record of all quality control tests, etc. be maintained in the offices of the contractor. The subcontractor shall not further subcontract this work. The contractor shall submit the work program for the whole project, which shall be comprised of the work program for this 20 kilometer length, which is proposed for subcontracting. all payments shall be made to contractor strictly as per provisions mentioned in Schedule H of the contract agreement. No payment shall be released directly to the subcontractor unless the contractor and the subcontractor both jointly submit a written request to transfer the payments in the joint account held jointly by the contractor and subcontractor. Any false information that can be excluded next. According now, total project length under subcontract will be 5.1 kilometer with total value of 0.25 crore. However, it is notified that overall contractual responsibility for successful implementation of the contract package, including the length considered under instant subcontract, lie on the contractor, and for any default, client would initiate executive action against Corsham construction asset. So, basically, the whole responsibility, everything, is remain with the contractor. Now, coming to the clauses, various clauses of this the agreement, the Lordship may come to clause 3.2. Page 39. Already here's a this is 3.2 obligation relating to subcontract and any other agreement. This 3.2.1 basically, my lord, to what extent extent the subcontract can be given regarding execution, the portion of the execution, the quantum for execution. That 3.22, my lord. That it has to be approved by the the authority. Then only
This has been read by Mr. Roy.
Yes.
These are for
Then,
approval of the subcontract.
Yes, 3.24, my lord. My lord. It is expressly agreed that the contractor shall at all times be responsible and liable for all its obligations under this agreement, notwithstanding anything contained in the agreement with his subcontractor or any other agreement that may be entered into by the contractor, and no default under any such agreement shall excuse the contractor from its obligation or liability hereunder. So everything is under there.
The contractor, his obligation, his liability is not affected by any subcontracting.
Any subcontractor. Whatever they have, that will be with them. But so far we are concerned, it will be response number 5, all the response to everything, and we can recover damages, etc. All this. Now, let me come then to my lord. Here the payments are made in at various stages, even advance payments are also made. The contractor requests mobilization, then accordingly 10% have been given in advance. Then milestones are there by this particular date, particular period you have to complete this much, and accordingly payments are given. So that way, the payments, it is not that only after completion of the work. Seen even in the approval letter, it is what something about 27 crores rupees was total to him, and out of that his claim is only 11 lakhs at the time of termination. So it is not that he did not receive any payment earlier. During the subsistence of the contract, he was getting it. Different time, different length was given.
No, we had put a specific question to him. He has said that he has not been paid a single paisa.
No. Milestones are there, never.
There is nothing in the affidavit filed by.
Well, this is not the question even raised in the he has not said in the petition that he has not received a single pay. And the calculation, everything has been given. How much the contractor has been paid. We don't pay him directly. Whatever bill are raised, it is raised by the contractor to the authority engineer, and then we pay to the contractor. From contractor he reimburses. And unless as per the terms that they have given joint account with a joint consent of the contractor, that payments can be directly routed to that particular account, that could have been done, which is not done here. That's the approval letter itself.
Were you made it a payment or not?
No payment. Okay. Lordship,
If
what
it
my
is
learning,
not paid, then it is the Corson Koban who has not paid. But so far as we are concerned, at different time, H civil and J civils are there, my lord, different milestones and the payments, including advance payment, etc. If you require that, my lord, specific inspection also, how much,
Where is your statement?
Lordship.
Where is the statement that you have not been paid anything?
We have stated Lordship, page 11 of the deed. Para 30.
No. Whether this is the entire amount or this is a part of the amount.
No, this is the remaining amount payable. Payable.
Understood. 11 crores which you are now claiming is the amount which consists of the entire amount for the work, or apart from this amount where you pay something in
No, this
advance.
is For being the value of the works done by the.
So, Sakya. This
And this is not disputed. The respondents have admitted in their correspondence. Lordship, when the original contractor did not do any work, NHI official has issued letter that work of the main contractor is nil. So whatever work has been done, that has been done by the petitioner. There is no dispute. And Annexure 7, Lordship, what my learned friend has submitted, one vital point is, Lordship, in Annexure 7. Yes, clause B. Lecture 7, page 153, whatever my learned friend has produced, place before your lordship. The NHIDCL officer do not know what are the clauses of the agreement. 153, lordship, page, clause. Lordship, this is letter by dated 4/11/16 issued by the GM planning, who is supposed to be the boss of the department NHIDCL. Lordship will see the clause Roman 2. The subcontract will be governed by the contract agreement signed between Ministry of Road Transport, a contractor, Person Gabro, and the tripartite agreement that is regarding earlier authority, Lordship. So if a subcontract will be governed by the contract agreement executed between the NHIDCL and the Person Caribbean to this company, Lordship. So it deals with subcontract will be governed. If it is governed, Lordship, I am a party to the contract. How there will be a futile submission that there is no privity of contract?
that clause corresponds to clause 4. Rest of the clauses are there. Whoever subcontractor or the contractor may have their own terms, but then subcontractor has to abide by the conditions that has been mentioned. Otherwise, contractor will be
If I am
liable.
not a party.
Otherwise, contractor will be liable. But that's what how much for this contract already payments have been.
But this letter, 4/11/2016, has been issued only in the context of the petitioner, not for a general purpose. See the contents of paragraph 2. based on your proposal submitted for giving subcontract to Green Decker
Yes,
for additional length of so and so,
yes,
the proposal has been approved in principle.
additional length, yeah, earlier length has been done, my lord, this is additional length that is.
Additional length, but
Yes, sir.
as a subcontractor
Yes, subcontract.
is eligible for execution, subcontract will be governed by the contract agreement.
Because we have to approve. We have to approve appointment of the subcontract, and for that, clause 3.2.2 and 2.3.2.3, there are some criteria of the subcontractor. So that having been fulfilled, we said you can appoint him. That much. So this is the, therefore the approval. Only to that extent. And so far as this, the clause that has been referred, this subcontractor will be governed by the contract agreement signed between so and so, so and so, so and so. This subcontract, my lord, subcontract between him and the person covered. It has to be in the consonance with the principal contract. So therefore, 3.2.4 is there. Notwithstanding
But the
anything.
documents which are before this court produced by him as well as by you and endorsed by you as a counsel representing the NHIDCL. It's not a case that you do not recognize him.
So far
You
as
not
this-
only recognize him, but you only give him the status of a subcontract in accordance with the terms of the contract.
Yes.
Now, with broad thinking,
Yes.
the work is of two components. Jaji to Dorhat to Jaji, Jaji to Demo. Jaji to Demo, we are not concerned. Might have been given to this company, might have been given to somebody else. We are not concerned with this present case. Petitioner is the subcontractor for Dorhat to Jaji. He has done the work. He has raised a bill. In the meantime, the Swedish company fleds away. You have some recoverable from the Swedish company, so far as the other part is concerned, with which the petitioner is not concerned. Now, for that part, will you make the petitioner a victim?
Making him, he has.
So where will you go now? Where will we
Yes,
get?
that is, that is there, my lord. That he has executed. That's what I've been saying. My lord, he has executed. It is not that we are not saying that he did not execute.
No, asking him to file a suit for recovery against the Swedish company, I think will be too much.
But in one of the additional.
To be very technical,
One
you
of
may
the
be correct in submitting that technically he has to file a suit for recovery from the Swedish company because your duty was to pay to the Swedish company and not to him. And it is for the Swedish company to make payment to him. But here is a case where you have not even paid to the Swedish company. You say that this amount we cannot pay because the recoverable from the Swedish company is more than what we have to pay to him. So if we pay, tell me, the public exchequer will suffer. Difficult to accept.
Already 9% of the public offered directly. In one of the additional affidavit, he has said that the respondent number 5 has submitted an application for, because there is another clause for grievance redressal. But so he has submitted an application portion cover that also he's relying on that, and we have not considered that. And in reply, we said that till date of filing or till particular date, we did not receive that. That
Notice of arbitration.
Notice or whatever application for conciliation. Otherwise, technically, bound by the agreement.
We go by technicalities, but when you see that there is no dispute regarding the execution of the work, completion of the work.
Yes, the argument has been made with regard to section 70 also. That is principle that has been laid is correct. That person cannot be unjustly enriched. So now here is a case, my lord, we are not unjustly enriched. We have recognized his work, we have valuation, we made the valuation of his work. And to the.
So what does he do? He has bank loans. There is a servicing proceeding against him. 10 crores is pending, 4 works done. Just imagine the plight.
No, that, I have.
Now, if your reaction would have been that he had not done the work, the claim is not bona fide one, or the work done was not proper, half done, or bad quality, those are not even factors for consideration, not matters of dispute. Under those circumstances,
Because the clauses are there, how we can recover the damages, etc. Those clauses are there, clause 30 are there, the clauses are there for which they have adjusted the amount. But
no, even after adjustment, that page I have shown you, 157, I think,
so that is with regard to this particular contract only.
page 359.
That even in the affidavit, we have clearly said, for this melody, the valuation become positive. Positive means 10 lakhs and not.
10 crores.
10 crores to high amount for me. The 10 crores and odd melody is in positive side, that is the.
10 crores is too less for you to mention, that's why.
Person.
Your client is a big client,
That's good.
hundreds of crores.
All public money, they have to be, they are custodian of the public.
You must be
Yes, they
thinking
have
of
to
10 lakh crores. 10 lakh crores can be also be
They
possible.
are collecting billions of rupees per day from toll taxes.
And they are doing works also, good works. The achievement by National Highway during this period is something which was not even dreamt of.
It is correct.
The corridors, east-west corridor, north-south corridor.
But,
Okay, we close this.
one thing, my lord, the chief may, my lord, also I cannot concede to that extent also, but then, my lord, since he has said that there is an application submitted, may file an application and the authority taking the total of all the actions.
We had given the letter, I have annexed along with the, nothing has been done.
So
Simple.
that's what I'm saying.
Now, what we had thought about that option, but on the affidavit, you have denied the claim. After putting it on an affidavit, will you be in a position to reconsider? If you think that you can seek the instructions and independent mind can be, an open mind can be applied, then a matter will be different. But otherwise, your stand is on record, is a part of the affidavit,
That's what.
and that is approved by the highest office. So after that decision is taken to defend this case, to rethink, to reconsider, you need to have the opinion of the highest authority, the approval of the highest authority. If you think that it can be done, then we can remand it back with without saying much. Otherwise, we'll have to pass some judgment.
The affidavit, we have also said that he has not availed the alternative remedy, so therefore this premature, he may avail the.
See, a matter of 2018, in 2023, holding it to be non-maintainable, and that was the hearing stage.
With regard to the alternative remedy.
That is a non-maintainability.
At the time of
Alternative
contract,
remedy means what? You are questioning the maintainability, he should have gone somewhere else, not here.
which cannot be raised at
No,
this.
that is, my lord,
Lordship, I have
See, a
filed
matter which has been admitted, and if the merits of the case is prima facie there is some merit, then Supreme Court has said at the time of hearing, it should not be a ground to deny a person an effective adjudication. Yes, so at the admission stage, you may be correct. Admission stage, motion stage. And also we leave the objections open. Name?
Lordship, page 2. Files.
Hmm.
And Gerang, state of Arunachal. Lordship, point was read. Ultimately, Lordship, Honorable Court, filed para 10. In the result, the petitioner titled the petitioner admittedly it has already been, the respondent party to deduct the amount as this point was that 10 lots. Other judgment is lordship. Page 3, page 3.
Principle will that the tax will govern the taken into
No, no,
consideration.
same. Almost
Here,
similar.
it is not a case that we are withholding his money. We have taken his bills to account, and then we have adjusted what we are receivable from the, and thereafter it has been 19 and all if we are still to recover from him.
How I can
So
be
therefore,
settled with the
question of whether unjust
RC and
enrichment or
removal.
section 70 coming into play, that does not arise. And recovery, whether we have the power or not, madam, that is clause 23, 24. Are clear.
That decision is not here, Wilson. Wilson decision is not here.
Page 3 lordship,
Of what? Compilation.
judgment,
Compilation. Compilation first case is
resolution has been done.
Madhya Pradesh.
With Mulchan.
Mulchand is it itself is how many pages?
Lordship, yes.
There's many pages, not page. How can there be page
Page
3?
2, parties are Lordship Wilson Jairang, appellant. Our on High Court, Itanagar bench. State of Arunachal Pradesh.
Yes.
That is there. Then Lordship, other judgment is Lordship, page 3, NHPC Limited, another budget.
Not page 3.
Page,
Not page, cannot be page 3.
I made page,
Now, judgment cannot be of one page.
1 page.
How can a judgment be of one page?
1 page, then I committed. I am supplying other. Another.
No, it cannot be page 3. First judgment, Mulchand is around 10 pages, so it cannot be page 3.
No. Separate judgment pages, Lordship. I have marked 1, judgment 1. Judgment.
No, this has been done serially.
Yes.
In this bunch, it has been done serially.
Pagination is not there, judgment serial number is. Continuous pagination has not been.
No, it is, this has been continuously paginated. Okay. We'll close this.
Some of the causes that of 2024 and 20. It's 24 specific provides 2.1 cannot be assigned by the contractor to person except with consent authority shall be entitled and without a subcontract has we have not approved for assigned.
Now, what about your letters where you have recognized him as a subcontractor?
That is approval.
Huh?
Yes, we have recognized.
Let us for a time being accept your submission. He is not an assignee, but he is a subcontractor. Will he not be entitled to a subcontractor which you recognize as the owner of the work?
He'll be entitled from the principal contractor. And that amount will be, the letter itself speaks how the payment should be made. Payment will be made to the contractor. And this process 23 regarding the termination, valuation of unpaid work, the termination payment, all these things are there.
Okay.
See, they had adjusted
Part
whatever.
3 SP counsel for the petitioner. Also heard Sri PJC Karan City Council representing the NHIDCL. Anyone else? Anybody else? This is there. They will be representing, I think, Ministry of Road and Transport. Okay. TKS Barua, let us see this. The hearing is concluded. Judgment is reserved. No, no. Okay. What is the matter?
That is the fishery matter.
18 matter, 18.
15 matter. Already the matter is hard, lordship, my lord.
Yes.
Now,
We have heard this matter.
yes.
18 is the,
Already, my lord, 5 years is gone.
how many years?
7 years.
Let another 2 years go. We'll hear it in 2025.
Lordship. No.
Easy for all of us. Without hearing matter goes.
If you lordship out our side, then I will call the senior, my lord.
Who is your senior?
Take him on.
Hmm?
Take him on.
AK?
Take him on.
Oh, KK Mahanta. He was heard. Which matter was this?
The settlement of
Settlement of debtor.
for 7. Respondent is the highest bidder, lordship. Plus, in that, after.
Highest bidder, not legal highest bidder.
No, that part will be high. And lordship had, on that day, asked me to provide instruction on one point, lordship, whether respondent number 7 was paying the KIST money regularly or not. So accordingly, lordship, I have brought the instruction, lordship, they are very regular in paying the KIST money.
It's a separate matter, my lord. It's not the merit of this case.
That is not in the merit.
Merit of the case.
The Digambara was there on behalf of respondent.
You were not given the contract for settlement. Why? Why?
There was an order by the High Court to consider the whole settlement process afresh. According to the process was being done.
Janavi, what is your name? What is your name?
Bhupen Chandra Das.
Upen Das.
Bhupen Das. I'm the legal highest bidder. I'm the scrutiny.
You are Namasudra.
No, sir. The respondent 7 is Namasudra. Ramdas Malo. I'm the Namasudra.
Petitioner is Namasudra, representative Bhupen Das. And respondent 7 is Bahuri.
The reason was he was not given the settlement that there be.
At that time, my lord, when he submit this tender, he is not submit Bakijai certificate, expense certificate, and actual fisher certificate, my lord.
But your value you have given is very less. 36 lakh 47,000.
Yes.
They have given 1 crore 48 lakhs 47,000. Huge gap.
Not the tax. No doubt, he is the highest bidder. More than 2 crores is the highest. There is the 2 crores. Another society has submitted 2 crores.
No, Ganakpura has some
180.
problem, I think.
There is a problem, my lord. No document is fulfilled by the respondent number 7, my lord.
If losses.
Bakijai certificate,
one second.
expense certificate, actual
One second.
fisher certificate,
Ganapura also did not submit certain certificate.
Hmm.
Ganapura is not before us.
No,
No,
We'll not go
before us.
we'll
Just was the
No, no, we'll-
highest bidder.
We'll go by your, then why are you? See, you cannot compete with the response number 7 by way of, in the financial
yes, ma'am.
bid. You can only say that they are not technically qualified.
Yes.
What is the problem with their bid?
Documents is required, so when the tender is
They did not have the required documents or what?
required documents, not when the scrutiny committee, the deputy commissioner.
Okay, we'll hear it.
Now, as long as their documents are in order also. All are in record.
We're remembering a bit. Let us. When?
After 1 week, lordship.
Date. I'm sorry? When?
Okay, well,
Hmm?
two.
A prayer for adjournment has been made on behalf of Sri D. Das, Learned Senior Counsel for the response number 7.
Yes.
7. As agreed to by the parties, list on 2nd of May, 2023. For hearing.
Okay,
2nd of May is what date? What day? Okay.
Tuesday. Maybe hard, pardon hard.
Hmm?
The rest they were rich cities.
We don't remember anything. If it comes, we'll take it up on that day.
My so please.